surfacing. What I'm on is that bank is with me on rephrasing how to repay the loan. And on one hand, they are proceeding. What I'm saying is that I'm making an offer as per them. I'm ready to deposit 20 lakhs even as on date and rest in 3 months. My right to redemption will be gone once the sale notice is issued.
So what is your prayer? What are you praying for?
I'm praying for listing for motion today. Otherwise, if
Today?
If I take the possession, I'll be on. 12th of March notice was issued. We pursued with the bank. Nothing happened. Elections in the midway.
When did you file?
Today. We are filing. We have the number.
Have it tomorrow.
Tomorrow.
I prefer listing a new petition tomorrow.
May I please, your lordship? Lordship, with the consent from other side, I beg to mention item number 12, lordship.
12.
Yes, lordship. Lordship, in this matter, private respondent has filed their affidavit today itself, lordship. And
12 is connected with 11.
11, yes, lordship.
Mr. Deori is there.
Yes, your lordship.
So what is it? Mr.
It is with respect to your lordship an
Unauthorized construction.
illegal and unauthorized construction by the respondent, your lordship.
You are the respondent in item number 12.
Yes, your lordship.
You have filed your affidavit.
Yes, your lordship.
You want to respond to that?
Yes, lordship.
How much time?
Lordship, 2 weeks time may be done.
Yes, your lordship. I'm only praying for a date if you
Who will they give a date?
Yes.
Okay. Your name?
You, Ghosh, lordship.
Sri U. Ghosh, Learned Counsel for the petitioner in WPC 6752-2025 has submitted that the respondent number 6 represented by Sri T. Deori, Learned Counsel, has filed an affidavit in opposition today.
Yes, your lordship.
Full stop. He accordingly prays for some time to file his rejoinder affidavit. Para. Also heard Sri T. Deori, Learned Counsel, who also appears for the petitioner in WPC 2435-2024, who also appears in the connected WPC, in the connected. Right? In view of the above, matter is adjourned by 2 weeks to be listed, or 2 weeks to enable filing of rejoinder affidavit. Para, list on, we'll have it on 6th of May. 6th May.
Very grateful. Your
Is there any interim order?
No, your lordship. There is no interest.
6th May.
Very obliged.
May it pleases your lordship, with the consent of the other side, I beg to mention item number 4, your lordship.
Yes.
Lordship, kindly the matter be passed over for the day.
4 is the 20 matter.
So today there is some personal difficulty.
When can you do?
Lordship, next week.
Next week? No. We can accommodate you for 1 or 2 days. 20 matter in 2026. Don't ask for adjournment.
Lordship,
the matter.
Friday, your lordship.
A prayer for adjournment. Have you informed the other side? A prayer for adjournment has been made on behalf of the petitioner. Full stop. However, taking into account that this writ petition is of the year 2020, this court has reluctantly granted accommodation with a direction to list the same on Friday next date. Mr. Bhuya?
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 22.
Yes.
Today's release. Lordship, there is some personal difficulty on our end, which is why we are seeking for adjournment regarding this particular matter.
You're for the respondent.
Yes, lordship.
Inform the other side.
Yes, lordship.
Okay. On a request made on behalf of Sri B. Gogoi,
Yes,
Learned AAG, matter is adjourned to be listed when?
lordship will list after 10 days. We will not.
Adjourned to be listed on, we'll have it on 8/28,
Lordship,
next Tuesday,
next Tuesday. Lordship.
28/4. Yes, twice correct.
May it please your lordship. Lordship, I pray for a listing of a fresh IA on Friday. What has happened?
May it please, your lordship? I beg to mention item number 16 in the admissions column of the daily list.
Yes.
With the consent of the other side, we seek time to file a affidavit in reply, your lordship, to the counter
You
affidavit.
have informed the other side?
Sure.
Okay.
For the respondents.
On a request made by Sri A. Kaushik, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Para, list on, we give a date. Today, we'll have it on 2 weeks. On 6th of May,
Lordship, there is an interim order, lordship.
6/5, interim order passed earlier to continue till the next date of listing.
Highly obliged.
Please also with the consent of the other side, I need to mention item number 1.
One.
On the ground of bereavement in the family of the conducting counsel, Mr. SP Sharma.
Okay,
Lordship may kindly fix the matter after 2 weeks.
okay. This court has been, a request has been made on behalf of Sri SP Sharma, learned counsel for the petitioner, who has been stated to be in bereavement. Para? In that view of the matter? No, para? In view of the aforesaid submission, matter stands adjourned to be listed on, we'll have it on 13th of May. Is it okay for you? 13th of May.
Then, order may be extended.
Interim order passed earlier stands extended till the next date of listing.
May it please your lordship, with the consent of the other side, I beg to mention item number 23, your lordship.
23.
Yes, your
Yes,
lordship.
what is it?
As the senior counsel, he is in bereavement, your lordship. As the mother expired. So kindly may accommodate for today, your lordship.
A request has been made on behalf of Sri B.D. Kaur, learned senior counsel, on the ground that there is bereavement in the family. Para? Have you informed the other side?
Yes, your lordship.
In that view of the matter, in view of the aforesaid submission, matter is adjourned to be listed on Agotunista. 21 Disilu, 13 Disilu. We'll have it on 13,
13. Oblige, your
13-5.
Lordship, in item 22, Lordship, there was an interim order, Lordship. Maybe continued.
22, okay. 22 the Asilu, interim order passed earlier to continue till the next day of listing.
May I please, your lordship,
Yes.
beg to mention a new matter which was filed on 7th April. So the till date, no, the matter is having.
Okay, we'll have it tomorrow. Tomorrow?
Lordship, I have made respect to item 6, Lordship,
Mm.
contempt petition, Lordship.
Mm.
The course of the Lordship, and into the case, the respondent is retired, Lordship. And I could not contact him, Lordship, because I have lost his phone number also. So I need some more time to, Lordship, file an affidavit, Lordship, in the case. There is direction to file an additional affidavit, Lordship. My friend is there, Lordship, on the side.
Lordship, no objection.
But these are matters are pending since 2022.
Yes, Lordship.
So,
In
but
fact,
they left.
Lordship, the writ petition has become infructuous, Lordship.
On a request made by Sri N. Upadhyay, learned counsel for the respondent, matter is adjourned by 2 weeks to enable him to.
Lordship.
No, 22 May, 2 weeks to enable him to obtain further instructions.
Lord.
List on, we give a date. List on 5th of May, 5th of May.
Lordship.
You get enough time.
Lord.
5-5.
Lordship.
Oblige.
Oblige.
What is your name?
R. Sharma, Lordship.
Sri R. Sharma, learned counsel for the petitioner is present.
Item 2.
May I please, your lordship? Lordship, kindly pass over the matter for time being, as Mr. Ayabuya is on another board.
But only time being, 16 matter. Ask him to come. We're going to finish this matter, whichever way it goes. Okay. What is the matter, Mr.?
Sir, regarding the claiming for the conversion of forest village, your Lordship.
Conversion.
Yes.
Is it possible? I don't. Let him come.
Yes, Lordship.
Item 3.
Yes, what do you do for 2019 matter? None appears for the petitioner in call. Petitioner on call, whereas, who's there? Yeah, for the railways.
1, 2, 3.
Whereas Miss
4, 5.
R. Bora, learned CGC.
No, I am the senior counsel.
Okay, learned senior counsel radio, comma, Miss A. Gayan, learned CGC. And Sri S.S. Roy, learned counsel for the respondent number. Who are 4 and 5? Who is 5? State Council. and last but to end, and A. Bhattacharjee, London Standing Counsel, Revenue Department. Para. This case was last listed on 18/11/2020. Full stop. Para. In the interest of justice, matter is adjourned to be listed on Thursday. Date it is however made clear that in case of further non-representation, this court would pass appropriate orders. What is the subject matter?
The eviction also.
Is there any interim order?
Status quo was directed to maintain the status quo.
Affidavits filed.
April 5, 21 in the year.
Okay. Day after tomorrow.
Yes, public.
Item 7.
My senior.
Who is your senior?
Yes, Lord. Court number 8, kindly pass over the letter for kindly.
None appears for the petitioner on call, whereas the respondents are represented. Para. In the interest of justice, matter is adjourned to be listed on Thursday next. Thursday. Date to the Prohi.
Item 8 and 9.
Lordship, I have received one instruction from Co-District Commissioner Gulukgand. Here it says that the settlement issued in respect to the petitioners falls within Bongaigaon Revenue Circle. Given that the petitioners are residents of Bongaigaon Urban Housing Refugee Colony, Bongaigaon, and the subject matter involves local premium calculations there, the case does not fall within the administrative jurisdiction of Dhubri district. Perhaps Lordship may grant us some time, we have to write to the DC Bongaigaon.
Wow, this is the party, Mr. Ahmed.
Lordship, yes.
You get the instructions from Bongaigaon DC?
My lord, similar issues, my lord, is involved in some other cases, lordship, a series of cases, lordship. The honorable court, my lord, has issued an order, lordship, 18/3/2026. My lord, may I pray, my lord, these two writ petitions may be listed along with those writ petitions. This is the order, lordship.
Mr. Bhattacharjee, what do you say?
This is the order, lordship.
I know, there are certain matters.
Yes,
Heard 3 M.H. Ahmed, Learned Counsel. You appear in both the matters, Mr. Ahmed?
yes, lordship.
Heard 3 M.H. Ahmed, Learned Counsel for the petitioners. By order. Also heard 3 H.K. Hazarika, Learned State Counsel, as well as 3 A. Bhattacharjee, Learned Standing Counsel, Revenue Department. Para. 3 Bhattacharjee, the Learned Counsel has submitted that though instructions were sought from the district of Dhubri, from the communications made, it appears that the appropriate authority to give the instructions would be from the district of Bongaigaon.
Yes.
Full stop. He accordingly prays for some time to obtain the appropriate instructions. Para. Sri Ahmed, the Learned Counsel for the petitioners, has also informed that there are few other matters on the same subject, including WPC 4181.
Lordship. My lord, this is 4181.
4 of 2023. Para. In view of the above, matters are adjourned to enable the Learned Counsel for the respondents to obtain the instructions. Full stop. It is also directed for listing of these matters along with similar matters, including WPC 4181 of 2023. Okay. Adjourned by Koluniki. Adjourned by.
Yes.
Adjourned by. And adjourned by 3 weeks.
My lord, in that case, my lord, date is fixed, lordship.
What is
case,
the
my
date?
lord, it was fixed on lordship. 11 11th of May, Lordship.
11th of May.
May, Lordship.
Order adjourned by 3 weeks to rahi jabo tu. Okay, ঠিক আছে. Adjourned by 3 weeks ne lagi likhi. Okay.
Obliged.
In item 10, Malad, I pray for some accommodation. Malad, I am not on record in this matter. This matter was being looked after by Mr. Pushilal, who unfortunately has passed away.
Okay.
I need some time to file my wakalat.
You have the records?
No, Malad, I'll have to reconstruct. I've already asked for the brief and all.
We'll done sometime. The
3 weeks time, Malad.
conducting council has passed away, so we'll grant some time. How much time?
3 weeks time.
What is the matter, Mr.?
Malad, there is some mutation order was challenged because
Mr. Ali appears for whom?
private.
For respondent number 4, your lordship, this petition which your lordship goes through, this is regarding mutation. According to them, there is access land, your lordship, in the mutation. So these things are always dealt with.
Where is civil court?
Startle officer, then the ADC.
Hmm.
After ADC, your lordship, because they are the appellate authority. And it next board of revenue, your lordship, if not satisfied under article 226.
We'll look into, we'll consider that respect.
Efficacious alternative remedy is there, your lordship. That's why, your lordship, this petition otherwise also not maintainable because granting mutation in access land is not a fundamental right. Violation of fundamental right.
We'll consider that. Let him come prepared. We fix a date, Mr. Ganguly.
Lordship. Lordship,
Hard-
can it be on 29th of next month if possible?
Okay.
Subject to my senior's convenience. 29th,
Date is okay for you, Mr. Ali?
29 May.
Heard Sri A. Ganguly, elected council, who has submitted that he has entered appearance recently as the earlier conducting council has passed away. Also heard Sri H. K. Hazarika, Learned State Council, and Sri S. Ali, Learned Council for the respond number 4. You are also there. Then H. K. Hazarika said, "A. Bhattacharya Likhiba." And Kuriba, last full story, Ali to Belek Likhiba. Sri S. Ali, Learned Council, appearing for the respond number 4, has also raised a preliminary objection on the maintainability of the writ petition. Full stop para. Be that as it may, and in the interest of justice, matter is adjourned to be listed on
29th May.
29th of May. Then on that date, we will also try to answer to the query raised by Mr. Ali.
The facts are all disputed. Disputed facts, how there can be 26.
Deeply obliged.
You think about Mr. Ganguly, if you
No,
can
I'll-
advise your client,
Lordship.
and if this is a formidable ground, then you can advise your client to withdraw and go for the
for the
whatever
appropriate-
remedy is there.
Item 13.
Sir, your lordship has seen the order dated 11/10. 10/11. Well, the joint verification report is to be held by the members.
10-11. Has it been done? Mr.
One report is available.
Verification was done in presence of the parties.
Copy that, yeah.
Microphone ko honest and necessary.
Affidavit.
Evaluate. Honest.
May I file one affidavit to bring it on record? At least they will get a chance.
Okay.
Look at that.
Were you present in the verification exercise, Mr.
Madam,
Sayola?
Just now, I have no information, madam.
No. Instructions from your client.
No, I have not such.
You're taking the instructions, they might have been present.
Like,
Heard Sri G. N. Sayola, Learned Senior Counsel assisted by Sri Sharma, H. K. Sharma, for the petitioner. Also heard Sri V. Gogoi, Learned AAG Assam. Para. Sri Gogoi has submitted that pursuant to the order dated 10/11/2025, a field verification was made and a report has been prepared, a copy of which has been forwarded to this court, para. Since the outcome of the joint verification may have some may have a role in the adjudication process, let the same be brought on record by way of an affidavit so that the petitioner is aware of the same. Para? Let such affidavit be filed, enclosing the relevant reports within a period of 2 weeks.
Yes.
2 weeks. Para? List this case on today is 21st. 2 weeks. We'll have it on 7th of May. 7th, Mr. Gogoi?
Yes, we'll file it before.
Okay. You can serve a copy,
Yes,
photocopy.
I'll file affidavit immediately.
No, you will file an affidavit, but we'll retain a copy of this.
Yes, yes.
Photocopy করিয়ে দিতে হবে। Original to না রাখলে।
May Prima, before my learned senior starts, this matter has been dealt by Mr. R. Borpujak. Has some difficulty today. He's in the midst of an argument in court number 1. Can it be posted in any other date?
What is the matter, Mr.?
It is a land acquisition compensation matter. Because there was a direction from the district judge as well as from the High Court, my lord. In a particular way, it has to be done, my lord. So that has not been followed, my lord. They said that there is absence of records. So we have appeared before the authority and we have submitted all the records. That could have been considered, but it was not considered, my lord. That is the finding.
You provided with the relevant
Relevant
records,
records.
which you, according to you, could have been considered,
Yes.
which they have not
No.
done.
Form B, especially Form B for the purpose, my lord. Form B, we have also produced here also, my lord. They could have done it. They have not disputed Form B also. They are.
When can Mr. Borpujari be ready? Tomorrow or day after?
Yeah.
Day after tomorrow, Mr. Roy?
But I mean, I'll be out, my lord. Let it be on 27 Monday, my lord.
You should not go out too often.
27 Monday.
You should not go out too often. You should take rest and be at Gauhati.
But 1 minute, my lord. Tomorrow, my lord.
Tomorrow?
No, no.
Tomorrow. Tomorrow will be difficult. Either Thursday or next Tuesday.
Monday, my lord. Next Monday, my lord. Or Tuesday, my lord.
Next
any day,
Tuesday.
Tuesday.
Next Tuesday. Heard. 3 Year Royal London Senior Counsel, assisted by Dr. B.N. Gogoi for the petitioner. Also heard on the petition, don't say. Sri A. Bhattacharjee.
Yes.
London Standing Counsel Revenue Department has, however, submitted that the brief is entrusted to his colleague Sri R. Borpujari, who has some personal difficulty today and has accordingly prayed for some accommodation. Para. Considering the above, matter is adjourned to be listed on Tuesday next date.
My only, my lord, I'm to tell you, because presently High Court will not decide the calculation of the compensation. So matter at best will be remanded back to the district judge.
Assessing authority.
Yes, assessing authority to decide it, my lord.
Okay, let's see.
Because that is not possible on the part of the.
Okay.
Obliged.
You are a tea garden or what? What do you
No,
own?
my lord. Prabhat Barua, my lord, Besh Barua, Prabhat Barua, the Jamindari, my lord. The land was taken under the Jamindari Act.
Gwalpara.
Gwalpara. Gwalpara, Dhubri. And 1957, my lord, it's long 69 years.
Okay, let us see.
15.
No, this is for the purpose of clearing a common road between the family members. Your lordship may kindly see order at page 30.
We take this for final disposal?
Yes. This was in 138 proceedings.
Just give us 2 minutes. Mahanta for respond number? Five, six, seven, eight. Reply affidavit is not required. Huh?
They file reply affidavit.
No, your reply, rejoinder is not required. Because last time you had paid for some time to file rejoinder affidavit.
It is there. We have filed a rejoinder.
You have filed?
Yes.
Okay. But it's not been
Nothing.
reflected. Rejoinder খন আহা নাই নেকি? আহিছে দেখোন C. ইয়াতে কিয় দিয়া নাই? C বুলি লিখা নাই। C বুলি লিখা আছে ইয়াতে C. ইয়াতে লিখা নাই। লিখিব লাগিব। Yes, what is it? What is the
Your
case
allotment can you see page 30?
38,
Yes, 30.
30.
Yes, petitioner's father filed a miscase for clearing the pathway belonging to family only. My lord, may I just read first part only?
Just a minute, please.
30.
Oh, you are related to the
Yeah,
current.
relatives. my lord.
Who is
Only the
Mr.
common- Same family, common path has been blocked.
Petitioners and respondents,
all.
private respondents, family members?
Yes.
Same family. And what is the grievance about?
Grievance is, my lord, that path is blocked by that the other members of the family. They are not allowing the members to go through. It is blocked. 10 by 20 feet.
Mr. Monta, why don't you sit and talk?
My lord,
It is not their case, my lord.
No. Why don't you?
No, my lord, your
No.
lordship.
We are not on the merits. Why don't you sit, talk, and resolve?
now what has
My
happened?
lord, I am
that-
just submitting, my lord.
It has to- it has- it
Now,
has
my
to-
lord, you go clear, same family, same brother and own brother and sister, my lord.
my
No,
lord,
those are okay.
They are
Let-
losing in all the court marriage. We ask
No,
that.
No.
Let us.
Now, my lord, is open. Now they more wide. That is their case, my lord. If your lordship kindly sit.
My
Oh,
lord,
no, wait. No, we are not hearing the matter
I
on
understand.
merits.
I am with you, my lord.
Mr. Das, there is a big trust on the mediation process.
My lord.
Why don't you sit and talk and resolve these matters once and for all?
thing is that my
Here,
lord,
in the High Court,
I am ready, my lord.
in the High
I
Court.
have no problem, my lord, but.
These are matters which are ripe, which are perfect for mediation.
My lord,
If we
What they
can,
are saying, my lord, what they are, no, I have no problem.
we get,
We have also
we are not,
We have no
Go by
High
the.
Court is
What
not
they are
resolving
saying-
matters, how wide would
What-
be the road of a family member.
My lord, I am.
You
In
sit,
the same campus.
you sit, you talk, there will be a mediator to facilitate your resolution and it will be resolved.
Yes,
But come without any ego.
no.
Sit
ego.
without any ego.
There is
and,
no ego. My lord, only thing is, my lord, what they are saying that it has been resolved in a title suit. We are saying it has not been resolved in a title suit. And they,
Mr. Das, forget about litigation, forget about litigation,
Yes,
forget about the decrees. You
So
sit,
is it their case that already the road is blocked for everyone?
Mr.
That is
Mahanta,
not the case, my
if you have this attitude, your client will have another bigger attitude.
Yes.
You have to advise them.
Already advised them, my lord, that they
my
say.
lord,
that
let
there
it
is
go to
nothing.
mediation. My lord, I
Your
have-
lordship kindly see that your lordship their own document, what they say, even the page, next time.
Okay, we are not going to the merits. We are not going to the
Your lordship
Heard.
kindly
So
already it is.
we'll make an attempt. If it fails, we'll come back. Okay. We are not closing your doors. Heard Sri Bididas Learned Senior Counsel assisted by your name?
Jailotha, Lordship.
Jelotha, for the petitioners. How many petitioners? One. Also heard Sri B.J. Talukdar, learned additional senior advocate assisted by Sri Medhi. Full stop. Sri T.J. Mahanta, learned senior counsel assisted by Sri
Ego.
T.J. T. Gogoi. Is appears for the responsibles 5, 6, 7, and 8. Full stop. Though pleadings have been completed and the matter has come up for admission hearing, comma, considering that the dispute is one between amongst the family members, comma, that too pertaining to a pathway, comma, this court is of the opinion that an attempt be made for resolution of the dispute through mediation. Para? This court Yes, do you have a mediator of your choice?
Mediator, Mr. Only your lordship may appoint.
No, my lord. Let it, my lord, in Jorat, let them appear with both the parties. in Jorat.
Wherever you want.
Because these are all.
See, we want to make it easy for the party. If
Yeah,
it is
Jorat-
easy.
Yes, because these, my lord, my
Jorat
friends,
is-
Jorat.
the old age lady, my lord, they are all.
Okay. We'll have it in Jorhat. We'll have it in
My
Jorhat.
lord, be better.
Mediator, this court accordingly. This court accordingly directs the registry to transmit the relevant records to the court of the learned district judge, Jorhat, who would appoint a mediator to resolve, a mediator to a mediator so that an attempt be made to resolve the issue. Para? Since the parties are already before this court, let the first sitting of the mediation be done on today. The question record on 11th of May. We give sufficient time. 11th of May, 2026. Whereafter the mediator would take charge of the proceedings. Full stop. Let a preliminary report be submitted to this court through the registry and the matter be listed for consideration on 8th of June. 8th of June, depending on which further orders would be passed by this court.
My lord, that already, that may be fixed before the court below.
They will appear on.
Which I already said, 11th, first date.
11, my lord.
11th. If there is any difficulty,
No.
the learned
Why
mediator
Jorat?
will,
They will appear before the district judge.
before the mediator.
The district, there is.
Mediator.
I think there is a center.
Before the-
All the
Before the
district,
mediator.
We have directed the learned district judge to appoint a mediator and he will appear before the mediator on 11th. If there is any difficulty on that particular date,
They will fix that.
that will, because
That's all.
if we don't fix the date, it will be very uncertain. That is the purpose of
That's
fixing
all
the
right.
first date.
That's
Okay.
Fine.
Okay.
Well, I'll.
Deeply obliged.
But without any ego.
Ego?
Mr. Mahanta.
Not my side, my
No,
lord.
not to
They are
Mr. Das.
Yeah,
Because-
Mr. Mahanta will not be there. Mr. Das will also not be there.
Yes,
Mr. Mahanta may be there. Nobody knows. Jorhat after all.
my lord. 17 and 18.
Really?
May I please, your lordship?
Yes.
Well, first, I want to withdraw, I want to not press item 18, my lord. The criminal petition, my lord, I want to withdraw. And I want to press only the bail, my lord.
Okay. Other side, who is appearing?
First side, my lord, for the state I am appearing. my
No,
lord.
Mr. Goswami, what about the private respondent?
Private
They are not.
respondent.
Okay, he's not pressing this. You are Anuddin.
Yes, my lord.
Heard Sri Anuddin, learned counsel for the petitioner. Also heard Sri MP Goswami, learned APP, Assam. Para. Sri Uddin, the learned counsel, submits that he has instructions not to press this petition. Full stop. Petition accordingly stands dismissed.
Item 18 only, my lord.
Or 18, dismissed as not pressed. This is on 18, okay? 18 gone. Okay, so AB will press.
Yes, my lord.
Okay. 18 to go, huh?
Just before starting, my lord, I just want to praise my lord. The box on which I though names are shown, my lord. But nobody is representing the victim, my lord. I have that is required as per the High Court.
Oh, yes. Where is Mr. A. Chaudhary?
Yes, yes, yes.
Can you have it tomorrow, Mr. Uddin? Tomorrow?
Maybe.
Can you inform who is A. Chaudhary? Arshad Chaudhary? Who is A. Chaudhary? As Islam, A. Koshar? Any idea?
My lord, I have no idea, my lord.
Asani number something.
Come tomorrow.
Oh, item 18 was proceeding. My lord, they were in item 18, my lord.
No, even in 17.
Item 18, who is
Even
already.
in
I have not
17,
pressed, my lord.
the
In that
Victim or informant is made a party as respond number 2.
Yes, my lord. So on amicus may be appoint, my lord.
No,
Because
if-
already we have taken the steps, but they have not appeared, my lord. Initially, we have taken steps.
let us see.
Yes, item 17. Other side only individual criteria, please.
There was a direction to serve the victim or the informant.
Lordship.
And rightly so, this is a matter involving the POCSO.
Lordship.
Is there a rejection order by this court earlier?
Well, actually, earlier, my lord, advocate, defendant advocate, my lord, he stated in the petition, but not annex, but I have collected the reject order, my lord.
Where has been stated in the petition?
Yes, my lord. It has stated, my lord, that is page 4, paragraph 4, my lord. Of petition, my lord. It is the
2 applications were filed earlier.
Once, my lord, withdrawn, my lord. And it was rejected, my lord. And before filing the charge sheet, my lord, the will was rejected. And at present, my lord, charge sheet is submitted. In fact, my lord, the FIR was filed against
Just a
another-
minute, just a minute. No, this is the same order. This is in 719. What about the other one?
Other one.
Second one, 341 of 2022.
Yes, ma'am. Yes, ma'am. I have collected.
You have given 2 copies of 7-1,
Yeah.
not required. এখন করে দিব পারিব।
হ্যাঁ, আপনি কি
Doesn't matter, draft. No problem. এখন করে দিব।
এতে খুব খোলা।
It was simply withdrawn.
Yes, ma'am. Once was withdrawn, ma'am, then another was rejected.
Now, what are your, but first we have to have an amicus. Is it, first, is it complete? Let us see.
Yes, madam, the kindly see office code, madam, 3.
Just a minute, please.
Yes.
We cannot transfer received by registry from the officer in charge. Black B. Okay, it's been served, so we'll appoint an amicus, okay? But since it's a bail matter, we'll have it in a short, within a short time. Okay, heard 3 N Uddin, learned counsel for the petitioner, as well as 3 MP Goswami, learned APP Assam. Para. This petition praying for anticipatory bail involves the POCSO Act, and accordingly, the victim has been added as respond number 2. Full stop. Office note dated Which one? Dated 25/10/2024 indicates that service report has been received from the officer in charge of the concerned allotment PS Borpeta, which is also tagged as flag B. Full stop. Since the respondent number 2 has chosen not to appear, and considering the implication, this court proposes to appoint an amicus curiae to appear on behalf of the respondent number 2. Full stop. Para. Accordingly, accordingly, Sri to number 3 to Miss number 3 is appointed as an amicus to appear in this matter. Full stop. Registry is directed to furnish a copy of the relevant records to the learned amicus within 2 days. Full stop. Let this matter be listed on, today is 21st. We'll have it on 29th. We'll try. Name of the amicus, learned amicus be reflected in the cause list.
I'm obliged.
3 number to লিখে লো file This you can take this back. We found it in the records.
May I please your lordship, my lord?
Yes.
Here, my lord, is an instant case, one incident took place in this, under the Dispur police station, my lord. And FIR has been filed, my lord. On that FIR, search sheet also filed, my lord. What happened, my lord? Subsequently, on the next date, another FIR has been filed, my lord, for the same incident, my lord. Same set of persons, my lord. And, my lord, another search sheet has been filed. I pointed out this point before the learned court below, my lord, and learned court below has, my lord, framed the search against the petitioner. This is completely a case of double jeopardy, Article 20, subsection 2. Today, I file an additional affidavit, my lord, to bring some important fact, my lord, that this person has filed a case before the, my lord, there is informant, my lord, before the Tongla police station, which was subsequently, my lord, amalgamated with, my lord, earlier first FIR, where I am facing the trial. Here I got the stay order. That may be called on record, man. That is important fact. Because 164 statement has categorically stated, I am asking the body of that particular person. And a person cannot be prosecuted and punished twice for the same Article 20, subsection 2, my lord. This is the story of the case, my lord.
You have filed an additional affidavit?
Additional affidavit.
Today?
Yes, ma'am. Today. And there are some minor mistake, my lord. I said
Just come on record.
We have it on record. We can have it day after tomorrow.
Day after tomorrow, my lord. Can it be Monday, my lord?
Because there's an interim order, I think.
Yes, my lord. I am always ready to do this case, my lord. Can it be second on Monday, my lord?
Heard Sri N.N.B. Chaudhary, learned counsel for the petitioner, who has informed that an additional affidavit has been filed today,
Yes, ma'am.
which however has not been tagged with the records. Para. Also heard Sri M.P. Goswami, learned additional P.P. Assam. Para.
Yes, yes, sir.
Let the additional affidavit stated to have been filed be tagged with the records and the matter be listed on
On Monday, my lord. How?
Monday 27th. 27, Mr. Chaudhary?
Yes, my lord.
On 27th.
Interim order shall be continued, my lord.
Interim order passed earlier to continue till the next day of listing.
This is a clear case of double jeopardy, my lord.
Let's see.
Yes, my lord.
You come prepared, Mr. Goswami?
Yes, ma'am. Yes, ma'am.
Item 20.
Lordship heard the matter earlier. No, my lord, the petitioner,
Pertains to what?
my lord, the petitioners were asked for riots, my lord, the tenants. And their claim is, my lord, for settlement under section 15 of the
Religious Act,
yes, that
1959.
1959, 15.
What?
They were the
what-
tenants, my lord. The admitted position is that they were tenants. I'll just take your lordship once again to the provisions of the Act. Your lordship will have the Assam State Acquisition Land Public Nature Act 1950. Assam State Acquisition of Lands belonging to religious and charitable institutions, Public Nature Act 1959.
Land and Revenue. In this book, which page?
Well, this book,
Oh, no, you're
lordship,
having a different book. Okay, we'll have it. Assam,
Assam State Acquisition of Land belonging to religious and charitable institution of Public Nature Act 1959. Lordship will come to section 15.
1-5.
Yes. Lordship got it. My lord, section 15 says settlement of acquired land with persons in occupation, subject to limitation prescribed under section 4 of the Assam Fixation Ceiling Land Holdings Act 1956, where the land acquired under this act is in occupation of a riot on the date of notification under section 3, it shall be settled with him with the following status. A, if he has acquired the status of occupancy tenant under the Assam Temporary Settled Areas Act, Tenancy Act 71, then the land in his holding shall be settled with him with the status of a landholder as defined under the Assam Land and Revenue Regulation 1886. And he shall, upon such settlement, be absolved from the obligations, if any, of rendering services or making payment of work or to the institution concerned in respect of the land or landholding. And if he has not acquired the status of a occupancy tenants, then he shall be settled with serve with him with the status of a settlement holder other than landholder as defined so and so. Provided, however, that notwithstanding anything contained in the Assam Land and so, the right to transfer of such shall extend only to the person belonging to and so. This is the section 15. It says if I transfer it, you must transfer to. Then section 16. Section 16 is the provision under which the government can settle it with others. Section 16 says where the land acquired under this act is not under occupation of a riot on the date of notification under this section 3, it shall be at the disposal of the state for settlement with the categories of persons preference being given to in the order of narration: cultivator, cooperative society, landless cultivators, agriculture, farming, the deputy commissioner or any other officer employed in this behalf of the state government may, for the purpose of settling such land, eject any persons upon authorized presentation. A tenant who is in occupation of the land acquired under section 3, but who does not take the settlement of such land shall acquire no right to titled interest in respect to so and so. Now, my lord will kindly come to section 3. Section 3, my lord. It says the state government, under this provision, my lord, the lands are acquired. The state government may, from time to time, by notification of State Gazette, declare that all rights of the land belonging to religious and charitable institution of public nature shall vest in the state free from encumbrances with effect from the first day of this so and so. Now, my lord says this encumbrance is defined in section 2C. It says encumbrance in relation to any land under the Act does not include the right of riots or agriculturists. Now, my lord, the government have filed various affidavits from time to time, my lord. The first affidavit was filed now, my lord, may I first take your lordship to an affidavit, my lord, the additional affidavit that we have filed, my lord, on 12/12/2024, my lord.
Mr. Roy, it will be beneficial if you give a brief narration of the facts.
That will be better, my lord.
Just intro, briefly, 5 minutes. Who are you?
No, my lord, we are the tenants under the acts. We are the tenants.
How many petitioners are there?
The petitioners are total. Huh? Oh, petitioners are my lord, 7 petitioners. 7 petitioners.
They are tenants.
They are tenants.
Okay. This land was acquired under this 59 Act.
And that they are tenants is an admitted position admitted by the government.
Okay.
There is no dispute on
Okay.
that.
These lands were acquired under this 59 Act.
These land along with other lands, their lands along with other lands. And the government, my lord, now is seeking to establish a school in the which attracting our land, our school or educational institution. We are against that. We have come against that. That you also will find at page 57 of the read petition. No content. Oh, my lord, page 60, I'm sorry.
60.
60 of the read petition. Order है ना? Lordship got it. With the last page of the
Just a minute, please. 60. Yes. This is 26/10.
That's right, bro. 26/10/2026, 2018. Under this, my lord, a proposal is sent for allotment of government land for establishing government model college, which attracts our land. We have come against that, and there is an interim order passed by this honorable court of staying this.
Yes.
Now, my lord, so far as the legal position is concerned, whether the government can allot, my lord, this land of the petitioners as tenants to others. Division bench there is a decision of the division bench on the Ugrotara case, my lord, making it clear that this land, the government cannot allow, you must be settled with us. And in fact, if your lordship take up a last affidavit that you have filed, my lord, on 12/12/2024, the government's own decision on it.
Who filed this affidavit?
We filed, my lord. Petitioner.
Additional affidavit.
Additional affidavit we have filed.
Dated?
That was in 12/12/2024.
Page?
Page, my lord, page 262. It is a letter.
Just a minute.
Dated 2nd April 1984.
Your affidavit was of 2024.
Yes, that is the last affidavit, additional affidavit we have filed. Bringing this
page 62.
Page 262. Serial number 262.
Oh. 2nd April. 2nd April 84. Letter?
Oh, yes, 2nd April 1984. I'll read this, my lord, which will make the position clear. My lord.
Yes, please.
My lord, it is letter written to the Deputy Commissioner Kamru. I am directed to refer to a letter quoted above and to say that government letter so-and-so has referred to allotment settlement of the land acquired under the fixation ceiling land ordinance 1956 as amended up to date, while the case of Sri Pradeep Kumar Hazarika and Sri Mohan Chandra Gogoi and others relate to the land acquired and settled under section 15A of the Assam State Acquisition Land belonging to Religious and Charitable Institution Act 1959. Here it may be pointed out that land acquired under the Religious and Charitable Institution of Public Nature Act has a different status, as the land so acquired did not vest in the state free from encumbrances so far as the rights of a riot, whether agriculture or non-agriculture tenants are concerned. Section 3(1) of the Act, read is Section 2C that I have read before, Lordship. It has been provided under Section 1, subsection 2 of the Act that it extends to the whole of Assam. Unlike the Ceiling Act, it adopts a separate definition of land, which does not confine to land meant for agriculture or purposes subservient thereto. Similarly, the definition of tenant under the Religious and Charitable Institutions and Public Nature Act includes both agriculture and non-agricultural tenant. It may be mentioned here that on the acquisition of the land under Section 3(1) of the Assam State Acquisition Land belonging to Religious Act 1959, the state stepped into the shoes of the institution, but the rights of the riots will continue under the government. In absence of express provisions in rent laws for the time being in force 59, Temporary Settled Act, Tenancy Act 1935, and the Non-Agriculture Tenancy Act 1955, as amended, the riots in non-agriculture areas of town civil station shall devise their rights by contracts, agreements, court decrees, length of possession of the land receipts are very much material in that regard. Section 15 of the Act, which inter alia provides where the land acquired under this act is in occupation of a riot on the date of notification under section 3, read in section 3(1)(2)(c) of the Assam State Acquisition of Religious Act 1959, makes it amply clear that this act endeavors to give settlement of land to all classes of riots, agricultural and non-agricultural. Naturally, Assam Temporary Settled Act does not allow recording of tenancy in the non-agricultural area mentioned on Tenancy Act 71 in section 15A of the Religious Act 1959 is therefore only for the standard to determine the status of the tenant, whether occupancy or non-occupancy of non-agricultural areas act. Therefore, subject to the ceiling limit under the Urban Area So-and-so Act, Rule 66, Settlement Rules So-and-so, occupants of such acquired land may be given settlement up to the limit of 1.5 bighas per family. These being the limit of conversion of annual land into a periodic within the town and peripheries. All non-agricultural tenants having use and occupancy over the land on the date of acquisition of religious census given settlement subject to census. So the position makes clear. Now, my lord, the government in no case, I have no objection if the government settles other lands beyond our land, well, or to any institution or whatever. But even institution also, they cannot, the manner in which they cannot do it, that must be settled under section 16 to landless persons and all. So this position has been made clear by, my lord, our High Court, my lord. I have to copy it. If your lordship kindly have a look at this. I'll read only the relevant paragraph. Para 2, your lordship will find the issue. Para 2 see the writ appeal before us has been carried from the judgment dated so-and-so, passed by the honored single judge in CR number so-and-so, so-and-so. Then fourth line, the moot question raised herein is as to whether under section 15 of this Assam State Acquisition Religious Act, the land acquired under this act can be settled to a person other than riots, privileged riots under the Assam so-and-so. The issue is decided, my lord, at paragraph 10 and 11. Para 10. From a close perusal of the above provisions of the Act as well as the scheme, it appears that no Doloi has the power to settle the land to devalue without the sanction of the managing committee. Under section 15 of the Act, government is empowered to settle the acquired land under the Act with those specified person who had occupation of the land and the status of a riot so and so. So this is made clear by the Honorable Court in the division bench. Now, my lord, the government has filed an affidavit. First affidavit that filed, my lord, your lordship will kindly see. Right. I mean,
now, how does it help you? The observations at 10. 10 is only a reiteration of the statute.
That's right. That's right. But
section 15 government is empowered.
Here, my lord, the government, here the authority has allotted the land to the other person, not an occupant of the land, not of the tenant. Therefore, the division bench has clarified that this can be settled only with the persons named in the statute, named in section 15. I'm just emphasizing that only. Just to pursue my case, the government has only, the Honorable Court division bench has said the government can settle only with the person named in the section 15 and no one else. It is only for that. Number one, kindly have a look at the page 61, an affidavit filed, first affidavit filed by the government, page 61. Yes, the serial 61. Lordship got it.
Who is R5?
My lord, R5 is the settlement officer, I think that's a respondent 5. Fine. Circular of adjournment.
Okay.
My lord, paragraph 6. Para 5, they have given the description of the land acquired, which acquired. And para 6, they says, with regard to the statement made in para 3 to 8 of the writ petition, the answering deponent begs to state that predecessor of the petitioners of the writ petition were tenants of the Baptist Mid-Mission. The government of Assam issued Kacha Khatian in the year 1977 as per the provision of the Tenancy Act 71, and the predecessors of the petitioners of the writ petition were a possession of the land of the said Baptist Mission, who was Pattadar. Further, the petitioner of the writ petition paid rent to Baptist Mid-Mission and not to the government of Assam. Again, it is important to mention here that after becoming Khas land mentioned above, said Baptist Mission filed one proceeding before the Honorable Gauhati High Court for getting compensation, and the Honorable Gauhati Court allowed the said prayer of the Baptist Mid-Mission, and which is now under Deputy Commissioner Kamrul for processing. Now, my lord, next paragraph 8. So, with regard to the statement, Mera 10 of the petition, the answer deponent begs to state that above mentioned lands were made Khas wide RSC number so and so and acquired government land so and so. According to the relevant records corrected by the so and so Assam government, they made it Khas. Now, my lord, then para 9. It says that with regard to para 11, the answering deponent begs to say the petitioner have stated correctly that the deputy Karimganj by letter dated forwarded the proposal for allotment of those mentioned land, ignoring the provision of provisions of law. Here it is mentioned that Deputy Commissioner Karimganj placed the said proposal before the Legal Land Advisory Board for public interest for Government Model College at Bajarisera, as there was no higher educational institution of the rural area. So this is what they have said here. They have said that since there is no educational institution, so they want to but the other affidavit filed by the Deputy Commissioner also filed an affidavit, my lord, reiterating this, that the land are
So, in the acquisition process, how much land was there?
acquisition process, my lord, total land for the same. Affidavit, the total land. My lord. Total. That's all. Yes. Government approved as DC affidavit. Oh, 39 bigha, 9 katha, 4 chatak. So, although petitioners were tenants of the aforesaid Dag. No, this is our area, my lord. 39 bigha, 9 katha. The para 5 of the deceased affidavit, page 172. Yes, my lord. It is 39 bigha, 10 katha.
Total area.
Total area. I say the land measuring 31 bigha, 10 katha.
Paragraph? Okay.
Paragraph 3 of the affidavit filed by the Deputy Commissioner, page 172, it says, with regard to sense, I say the land measuring 31 bigha, 10 katha 2 lecha, covered by so and so, so-and-so, herein referred to a scheduled land was recorded in the name of J.S. so-and-so. However, on a above scheduled land as acquired by the government, by land acquisition case number 27778, and the possession of the said land was handed over to the so-and-so. It is 31 bigha, 10 katha, 2 lecha.
And how much area you are occupying?
We have given our, my lord,
The entire area wants to be utilized for this education institution.
yes.
Entire area, because the impugned order which you have referred at page 60, proposal to have a government model college, that refers to the area as 31
That's
plus
right, that's right.
10 katha, 2 chataks,
Lordship.
which is the same area which has been mentioned in paragraph 3 at 172.
That's right.
So the entire area which has been
Entire.
acquired is now proposed to be converted into a education institution. In that case, you will be out.
I'll be out.
There was no areas which was not under utilization.
No.
How much area was under you?
We have given, my lord, I have to see, my lord, we have given our, my lord, Khatian and all. And next, I can give you a definite statement chart of our idea. Chart today. I'll give you lordship that, my lord, soon. Yes, chart. Yes. We have the record of individual possession, my lord.
You were 7, you said.
We
7
are 7.
petitioners.
We are
Total
7.
area will be how much?
My lord, I'll because I've got I'll make it out and then give you.
Please make a rough calculation.
Lord,
Let us know.
I'll give it. I'll give it. Now, my lord, the question is whether the government can, in view of the provision of section 15 of the Act, can deny us from the benefit of that provision or not. Because it is the statute which says it must be given to us. And after acquisition, this land of ours does not vest on the government. This is what this provision of section 3 read to section 2C says, and the government letter that I have read before lordship in my from our additional affidavit. The government themselves says that so far as this act is concerned, the status of the landholders are different. Earlier, the proprietor was we had the proprietors, and after the acquisition, the government steps into the shoes of the proprietor. And we remain the tenant under the government now. That is why they have, my lord, made the correction of the land record in our name. They have already made corrections. And Jamabandi record, our names are there. And the government, my lord, in our additional affidavit, they have filed allotted some lands to such tenants, my lord. We have annexed that, my lord. Made allotment in our additional affidavit. I have given the orders in our additional affidavit. The last affidavit that I have read, my lord, I have annexed with our last affidavit the some of the lands given to similar tenants. Those orders are there on record. Since
But those persons were not within this 31 bighas.
in fact, I don't know how they have given. Has to
No.
be. It is a proposal only. This is only a
No,
proposal.
if Mr. Roy, if the allotment has already been given to some similarly situated persons, and if those allotments are within this campus of 31 bighas, the entire proposal cannot be given for 31 because these are outside this area. Because we find we find a consistency with the impugned order 26/10/2018 regarding the area of the college, proposed college, and the statement of the deputy commissioner, where he states that 31 bigha 10 kata 2 chataks were acquired under the 1959 Act.
That's right, but this letter, the main proposal has to be seen, whether what is the extent of the land they want to take. This is not very clear,
No,
whether they.
Mr. Roy, this will be clear because if the proposal would have also encompassed the area which has been allotted, they would have been before us, more than you. Allotted land, how can you take away? You are on the status of a tenant, yet to be settled. But you claim your right and trace your right to 15, section 15, that you get your first right as a riot. And riot aspect, you say it's not disputed. That is your case.
That is my case. And in one of the affidavits, the last affidavit, they says that we will not be disturbed also. My lord, you kindly see that affidavit.
Who filed?
This is filed by
Page?
the page, my lord, 192. I have seen that, my lord.
It's part of the DC affidavit, I think.
No, this is by
No.
Revenue Department.
Revenue Department affidavit, my lord.
Page?
192.
192.
192, there is no new affidavit. Yes, there is an affidavit, you're correct. By R1.
Yes, my lord. Paragraph 13, I think it is there.
1-3.
Yes, it says with regard to statement paragraph 11 of the division, deponent denies the same as correct. The deponent begs to state that as per the report of the Eastern Settlement Officer Pathakandi, an allotment proposal including dark numbers mentioned in read petition is not under possession of the petitioners. They say then, but then I have given the dark numbers, it corresponds to the number petitioners and their possession of the petition or their predecessor, and after the land has been made khas land following due process of the land, a portion of the land was allotted in favor of the government, a portion, they said, the government so and so. Moreover, as per the statements made in read petition, the petitioners claim tenancy over dark number so and so, but Khatian distance, they have rights over portion dark number mentioned above, and therefore the allotment proposal has been sent covering the remaining portion of the dark number. They said since they have no possession over the said plots of land under consent, therefore the question of eviction does not rise. This is their said. So we are not evicted. But then if a lordship sees the proposal, our dark numbers are there.
What are your dark numbers?
Our dark number we have said.
Last affidavit.
Na prothom paragraph hi ache to. Our dark number is
Where have you stated?
page para 2 of the writ petition.
Page?
Page 4. No, where I'm sorry, para 5, my lord, na? Settlement government, Khatian, এটা তো Khatian প্যারা 2 তো দেখলে প্যারা 2 না The settlement of their Karimganj, para 5 minutes. Karimganj is granted Khatian number 23 dated so and so in respect of the aforesaid plots of land covered by DAG number 339, 340, 341, 343, 359, besides other similarly DAGs, situated DAGs. Then again, yes, para 6 also. Khatian number so and so, land under DAG number 393, 427, 432, 434, 438, situated according to the grandfather of the petition number 4, Gopichan Pal. And in one affidavit, the affidavit about
All Khatians and everything is on it.
DAG number this. Oh, yes, my lord. We have filed, pursuant to the order passed by this court, we have filed an affidavit that is on, Lordship will find at page 100,
100.
100,
Page number 100.
page 100, giving details about DAGs and the documents. At page 101.
In compliance with court order.
The Honorable Court was pleased to pass an order on 8/11/2023 to furnish the details. We have given the details. Total land also. So if the government says they will not disturb us, there is no question.
No, but that would be slightly dicey because the impugned order at page 60 encompasses the entire area,
That's right.
31 bigha. If the proposal to have a government model college is on the entire area, then the
nothing
question
will
of
be
not
left.
disturbing you will not be a correct exposition. You would be disturbed. But if that is what clarification we'd like to seek, is what is the proposed area of the model college. We would not be against its establishment of a college, but if both can be balanced without disturbing you.
I have no.
So first we need to know
That's
what
right.
is the area of the proposed college. It cannot be 31.
And if it excludes our land.
Yeah, that is the question. Then we may not be really required to answer your the query which has arisen in this list.
The legal issues.
We may not be required to go deep into it. What is 15? What is 16? But this clarification would come from Mr. Bhattacharya or Mr. Madam. Madam, you are for whom? Education department. But the allotment for the education institution is for how many? What is the area, Mr. Bhattacharya?
As per the impugned order, it is regarding 31 bigha.
But 31 bigha is the entire area of acquisition also.
There is one affidavit by DC. My learned senior will clarify that the land is 39 bigha. Out of that, 31 bigha has been given to model college. So apart from the land which is given to them, to the model college, there still remains some land. Maybe they are in possession.
8 bighas.
That is, yes.
8 bighas around.
Yes.
Now they have given the details of the land under their possession in the additional affidavit filed on 4/12/2023. Can you kindly work out what is the total area, Mr. Roy?
It says 15 bigha, 18 katha, 11 shataks. Page 103.
15 bigha, 18 katha, 11 chatak. So it cannot be. Even if its total area is 39 bigha, and he proposed to give 32 bigha to madam to establish the college. Then
It may not be 39 bighas only, because lots of, if your lordship kindly read paragraph 3 and.
see, there is one via media.
Right.
We can clarify that without interfering on your proposal to have a government model college.
Right.
We would ensure that the lands under the possession of the petitioner as tenants who got the benefit under section 15, that should not be touched.
Yes.
Rest you
We
can.
have already said some.
If that be so, my lord.
But in our affidavit, we have taken a specific step that they are not in possession. Secondly,
Hmm.
the proviso to section 15 will not benefit them, because they are not tenants as defined under the act.
No, their
Being
predecessors,
tenancy under
the predecessors were the tenant. They did not buy it. It was not transferred to them. They were the inheritors. The proviso, which gives a further condition that they should belong to the same religion, that is only for further transfer. A riot cannot further transfer to somebody who is not belonging to the same religion.
That's right.
We had passed that judgment in Pirola, I think. What was that case?
Yes.
Hotra, Nagaon, Borpeta district. That we had clarified. But here, it is not a case of somebody entering into the shoes of the tenant. Their predecessors were the tenant, and their names are also recorded. That is their stand. Now, if it can be in such a way that the education institution also is also existing without affecting the rights of the petitioners. But one problem would arise: total area under their possession appears to be of 15 bigha 18 katha. Then almost half will be gone. Whether this college can be constructed on an area of around 12-13 bighas, that is one problem.
My lord,
Maybe less for a college.
lordship may kindly come to paragraph 14 of our entry.
Page.
Page 65. Paragraph 14. That has a lordship.
Just a minute, please. Page 65.
Page 65, paragraph 14. That we figure to the statement.
Just a minute, please.
No.
This is an affidavit,
By
please.
the deputy, assistant deputy.
Yes,
No, no.
does falling under possession. They said
Just a minute. 60, it cannot be 65. It will be something else.
65, 175, my lord. It should be
Oh,
one,
that is enough.
175.
yes, it should be 175. my lord.
Just a minute, please.
No, but it would be. Okay, I said 175.
Just a minute, please. By R4,
My lord, it is by DC, yes, R4.
Rupok Mazumdar,
Yes,
Yes, yes.
Mr. Talukdar,
yes, ma'am.
Rupok Mazumdar. It starts at 171.
Yes.
That we figure to the statement, maybe
Paragraph?
paragraph 14 now.
Just a minute. Dated 6/12/23 or 4. Para
Paragraph 14. Then
14.
Yes. That we trigger to the statement made in paragraph 15 and 17 of the petition. I say that the land allotted in favor of the government model degree college does not fall. on the
Does
co-
fall. Does falling.
Not,
Oh, not here the night.
not.
No, that's
It
falling.
is correct.
Does falling.
No, no, in here also there is no not.
There is no not.
Oh, it was corrected by hand. Does not.
But here there is no correction.
No, correct. Does falling.
Under the position as per report of the SR. Then lordship may come to paragraph 13. Let's say maybe. That we trigger to the statements made in paragraph 11. I say that as per report of the Assistant Settlement Officer, Patragan, an allotment proposal partially included the ducts as mentioned in the petition, which is not under the possession of the petitioner, predecessors, has been allotted in favor, land which are not under their possession, that has only been allotted to the government body.
But it's contrary to the next para.
Moreover, as per statement of the petitioner, they have tenancy over duct number 341, 49, 51 fully. However, as reflected by the tenancy record, they had rights over portions of the aforementioned duct. The reason why the allotment proposal had been said covering remaining portion of the ducts.
In which they have neither tenancy.
Because this will, if we read conjointly, my lord, paragraph 3 and 4
Of
of that same affidavit, my lord.
3 and 4 or 13 or 14?
3 and
3 and 4, okay.
3 and 4 says, my lord. In paragraph 3, it says 31 bigha 10 katha.
Yeah.
আমরা 31 বিঘা কইছি নি আমরা?
Under duct number so duct numbers are this.
আমরা কত বিঘা কইছি?
That was
39
handed over
No.
to government by some Willington on 7/3/2001. And paragraph no, 5. The next paragraph, that is marked as 5. I say that the petitioners were the tenants, varieties of the aforesaid land, an area of 39 bighas, 9 kata, 4 sata of the aforesaid lands were acquired, apart from this 39 bighas. But this may be extra land. And petitioner also don't claim all of they are possessing all of the ducts. They say they are possessing 339, 340, 341, and 359. But there are other ducts. The total amount of land may be different. And it is also understand that we are not touching their land.
এটা 3 তো। 3 তো। তোমরা read petition টা 3 তো এরা হইতেছে দো petitioner tenants under action 13 বিঘা acquired on the government position the was handed over to circle officer. গীতা হয় এটা অন্য কিতাব করতেছে অন্য একটা কিতাব পাইবো কিতাব না গো ওটা তো করে না না তোমরা আগে তো বই নিজে নিজে লিখে যাবে নো লেখা আছে নাকি তারপরে একটু ওই যে কইছে তারা ও reply kita দিছি আমরা
এই যে reply টা references কোনো number 4 reference to
para 5
1 to 3 and 5. This one will highlight is reference to the order of prevention principle. This is one handed over.
As paragraph 14, my lord, 14 of the affidavit.
That are against documents.
There's something wrong because I have deleted the comments. Says that it doesn't fall within the. Statement at 15.
okay one
Last
বা এটা তো
This was the comments from where this affidavit has been taken.
my lord the
Reply to both.
the total land handed over my lord will be at 236 page.
It has to be more.
It is more my lord a huge land my lord. But the handing over letter is there my lord at page 236. Yes, it is, it tells.
Yeah.
Circle there. Here this is.
Filed in 2021.
এটা আমরা affidavit reply, yes. My lord will find at page 236.
Just a minute, please.
আমরা পাইবো। ঠিক আছে। 1746 বিঘা 14 কাঠা 12 ব্লেঞ্চ। Okay. আমরা বুঝেছি। আমরা ডাকবো Oh, enter record is 17416. Yes. Enter record of requisition is here.
How much is the total area?
Total 1746 bigha 14 kata 12 chotaks. It's there.
But the problem would arise because of the issue that your DAG numbers have been mentioned in the affidavit at paragraph 13. Namely 341, 349. Kindly come to page 175. Please come to 175, paragraph 13.
Yes.
The DAG numbers have been mentioned that these are the DAG numbers which were settled as per your statement. They
Yes.
have tenancy rights over DAG number 341, 349, 351, 353, 359,
571,
571, and 572.
full name.
Now you come to the impugned order at page 60.
I'm going to reply to the witness.
Page 60, the last page of your writ petition.
Oh, hmm? Yes.
See, 341 is also a part of this, but 341 kho is there.
Oh, yes.
Kho, not 341 per se. Then is 349 there? 349 kho is there.
Yes. And 339 is also our land.
339 is not your land.
Yes, Hassan.
No.
339 is 339.
There may not be an inconsistency. If you compare the lands with page 60 and page 175, paragraph 13. The only consistency or other matching are the dark numbers, but here in the acquisition process, those are kho and kho, all kho. This is a different dance.
339 as per our statement, my lord. 339 is also para 5. 339
Para 5.
of the writ petition. 339 is our dark, my lord. We have given 339 is our land. That's why I have marked it, my lord.
Para?
Para 5 of the writ petition. 339, 340, 341, 347, 359. 339 is our dark. Hmm? Hmm.
Out of these dark, my lord, in a statement in paragraph 5, they say 339, 340, 341, 347, and 359 are their dark.
Hmm? Hmm. 339 doesn't it? Oh, along with other ducks, you have said.
But 339 is the only, others are all different. Others are different. There may be some controversy with 339 that we can clarify. If it is under you, then 339 cannot be a part of this college. Proposed
Yes,
college.
we find 339, 340, 341, of course, it is kho. And 349 is our duck. 354 is our, no, 3.
Then it is 3494.
Oh, 349 is there.
Except 339, Mr. We have just checked, Mr. Roy.
Others are there.
Others are all different.
Others are,
Different. Others are different.
no, but the lordship.
Except 339, which may be.
No, 339, 341 is at page 45. 348 is page 45, 51.
341 is not a part of the impugned order. 341 is not
Yes,
part of the, no.
Oh,
Kho is different. Except 339. That is the only one which is overlapping.
and,
Others are all kho.
355
355.
at page 45. This is our line.
355 is not yours.
Yes, page 45, my lord will find. I think it's there. I have written 345. 340 also, no? No.
345 is
355. 355 is there, our land, my lord. 355, page 45 is our land. 355 is there, my lord, in the impugned order.
the impugned order is not 355.
Yes, 350 after 354.
But no, Mr. Roy.
Yes.
Kindly come to 175, the paragraph 13. From where do they come to this conclusion that these are the dogs in which you possess the land? Paragraph 13.
Para 13 of the
of the affidavit filed by the
Yes,
deputy.
the deputy commissioner.
There in this in the middle of the paragraph,
Yes, says 341.
they have given these dark numbers which you claim to be settled with or to be under you as a tenant. Moreover, as per the statement of the petitioner, please have you got this?
Yes,
Please read this. Moreover,
moreover,
as per
as per the statement of the petitioner, they have tenancy rights over 341, 359, 351, 350, perhaps 11, 353, 359, 571, 572. But we have mentioned about other dags also.
let us see paragraph 11.
Para 11 to the petition. Para 11 we have not. Huh? Para 11 we have said deputy commissioner so forwarded proposal so and so admission so and so. We have not said anything about the dogs here.
Five and six.
No, আমরা দাগের কথা কই গেছে। Para 11 we have not said about this. Government must make it clear, clearly must file a clear affidavit, ought to have filed. There are 3 different affidavits filed. First affidavit did not dispute anything.
Mr. Talukdar, while you were responding to paragraph 11 of the writ petition,
11.
11 of the writ petition, your response to 11 is paragraph 13. Correct? Now, 11, they have not stated anything about DUG numbers. From where do you extract this? That moreover, as per the statement of the petitioners, they have tenancy rights over so and so. This is not the statement in the paragraph 11. Rather, if you come to earlier to the statements at page, no, not 5 and 6, 5, the more, yes, 5, yes, 5 and 6.
5 and 6. These are dogs.
These are the DUGs.
They claim these are dogs. The at paragraph 6, these lands were not handed over to college.
But in Amin's affidavit, clearly responded para 11. They said whatever state is correct. The first affidavit filed by Estate Settlement Officer, they said whatever is stated is correct.
It says only the remaining portion. They might have been occupying portion of that dog. But the remaining portion has it appears.
But in paragraph 5 and paragraph 6 of the writ petition,
Right.
there is a specific averment that certain that lands under certain DUGs,
Right.
including 339, 340, 341 are
Including my lord 339, 340, 340.
and 36 and your impugned order at page 60 mentions 339.
330. Maybe a portion of 339 that I cannot stay on.
You may be correct.
It mentions
Oil of
about
the chemical.
339, 340, but 41 is cost.
Oh, that's correct.
Then 347. 347 is there. And 359.
See, it appears, the loud thinking, that the area is not confined to this particular, to 31 bigha, 10 katha, 2 chataks, on which the proposed government model college is sought to be established. It's a huge area. And admittedly, there are materials on record to show that the area which is under your possession is separate from the area, except few of the ducts, namely 339 and some other ducts. And Mr. Taludar also said that these ducts, some areas may be within the proposed college, some area may be within you. We can clarify that whatever is under you,
However, if your lordship clarify, then that's.
we can clarify that whatever is under you and protected by 15.
No.
Without those touching that,
That's that.
they can go ahead. They can go ahead with the college that will serve the public also.
We have no objection.
Yes, Mr. Bhattacharya, what do you say?
That is the only way. Otherwise, 99% of the work has been completed.
No, there is an interim order. How can?
No, without evicting you, perhaps you are not being affected.
Okay.
Then it's okay. Then it's better for us. If this construction has not affected you, then this construction would be outside the purview of your allotment. That's good.
No. Stay not. No, if the impugn order is stayed, I'm not sure. No? No, if the government doesn't disturb us, then what is this problem?
Mahanta for school. Which education department? Which one? Higher education. Higher education.
So the impugn order was stayed by this honorable court below. 4/2/2019.
There is no vacation of the interim order. There was an interim order, stay order, not limited by any time. How was the construction made? 99%.
That instruction I did not have.
Madam? See, we have this, that is why we have taken time to see if this interim order was modified at any subsequent point of time, giving leave to go ahead. But you have gone ahead.
At that point of time, whether there was any construction or not, that also.
No, what is surprising is the interim order is of 4/2/2019. The impugned order is 18, 26/10/18. They came to the court late around, but it is not possible to have the constructions before the interim order was passed. Because why we are saying so? In this communication of recent origin, 5/3/2026, they have stated that the allotment was of the year 2018, 30/12/2018, tender value, contractor, the formal work order was given in 2019, and period of completion as per the FW is 24 months. But what is most important in this communication is the target date. Target date of completion is 31/3/2026. That means the work has started sometime in the year 2024. So that is why we have taken the pain to see if any clarification order was there in 2024 or 23 that you can go ahead, which would be subject to the outcome. There is no such order. You see, this is interesting. You have a copies of this document? Can you show it to Mr. Talukdar? This communication is of March 2026. If you come to the enclosure in this, the accompanying enclosure, you will find on this 7th column, period of completion, 24 months. Have you got?
Yes, 24 months.
24 months. Thereafter, target date of completion is 31/3/2026. And therefore, 99%. If it was 24 months, if it is done as per this, it would have started sometime in 2024 March, if not earlier. But we don't find any leave being granted by this court.
24. Must have been sometime in 24.
Target date.
Target date is 31/3, so
26.
24 months.
2 years, sometime in 2024. If there was a stay order which is in operation of 4/2/2019,
They could not.
we may construe the stay order in a different perspective since work has been done. We'll not, but at least minimum should have been to seek a leave of the
Yes.
court
Yes, Lord.
that we would contract without affecting the rights. Kindly give us leave. You go ahead.
Exactly.
But we'll try to strike a balance that would mean that the objective was not to disturb the petitioners, which they are still in peaceful position.
Otherwise, they should have.
Because per se, they are not aggrieved by the decision to have a college. Their grievance is that you have a college, but you should not affect our rights.
Vis-a-vis their rights.
So we'll have to understand in that manner and try to strike a balance. Otherwise, the matters will not be in a very positive state. There's a stay order 4/2/2019, and it was not limited by time or it is not conditional. Simply, the impugned order did so and so shall remain suspended. Okay, well, that will have ভালো বনি এটা। You are 7 petitioners, Mr. Roy.
Lordship,
7.
7.
7 petitioners have joined together
My lord,
in this petition
my lord.
filed under Article 226.
With
Yes.
your lordship's leave,
Yes.
can I just?
Yes, yes,
for a
please,
moment?
please, please, no problem. Have joined together in this petition filed under Article 226 of the Constitution of India, seeking the following relief. Relief to put for the para. As per the facts projected, comma, land measuring about 31 bigha, 10 katha, 2 chataks, covered by dark numbers, ekhane dark numbers, synopsis of secret so had originally belonged to the Makunda
Yes, Lord.
Makunda Baptist Mid-Mission in the district of Karimganj. And the said land was acquired under the provisions of the Assam State Acquisition of Lands belonging to religious or charitable institution of Public Nature Act 1959, bracket hereinafter Act, full stop. The petitioners claim that their predecessors were in possession of the land as tenants, as riots oblique tenants under the Makunda Baptist Mid-Mission and were accordingly issued khatians in the year 1977, it's onwards, by the settlement officer, Karimganj, full stop. It is thus claimed that the petitioners were entitled to the settlement of the land in accordance with Section 15 of the Act, full stop. The petitioners claim to be in possession of the land since then, full stop. However, vide the impugned order dated 26/10/2018 issued by the Deputy Commissioner Karimganj, comma, necessary approval of the government was sought for allotment of the land for establishment of a government model college, full stop. It is the aforesaid action which infringes the rights of the petitioner, which is being challenged in the present petition. Full stop. Para. I have heard Sri P.K. Roy, learned senior counsel for the senior counsel assisted by Ms. as Dasgupta for the petitioners. I have also heard Sri B.J. Talukdar, learned senior counsel and additional senior advocate Assam, comma, Sri A. Bhattacharjee, learned standing counsel Revenue Department, and Ms. P.R. Mohanto, learned standing counsel Higher Education Department. Para. Sri Roy, they run the senior counsel by drawing the attention of this court to the averments and materials enclosed in the writ petition, has submitted that certain specific lands are under their possession as their predecessors were the khatian holders of under the erstwhile Baptist. In this connection, comma, he has referred to the averments made in paragraphs 5 and 6.
Lordship.
5 and 6. 5 and 6. Full stop. Additionally, comma, he has also referred to an additional affidavit filed on 11/12/2023 pursuant to the direction of this court. No, additional affidavit dated here, 4/12/2023, not 11/12. 4/12/2023, pursuant to a direction of this court, whereby all the details of the land under the possession of the petitioners have been given. Full stop. He has submitted that there is no dispute on the aforesaid statement of facts that the petitioners are indeed in possession of the lands under the aforesaid dugs on the strength of section 15 of the act in question. Full stop. He has also submitted that under section 2C, it has been clarified that encumbrance would not include the rights of a riot or agricultural or non-agricultural tenant. Full stop. For ready reference, the provisions of section 15 and section 2C are extracted herein below. Full stop. He has also clarified that the principles of law has been settled by the Honorable Division Bench in the case of Banikanta Sharma and others versus Assam Board of Revenue and others, reported in 2004, Suppli GLT 694, wherein the following has been observed. Paragraph 10. Paragraph 10. The learned senior counsel has submitted that the names of the petitioners have been entered into the Jamabandi, and further that certain lands have already been allotted to similarly situated persons. Full stop. He accordingly submits that in that view of the matter, the impugned communication dated 26/10/2018 would not be maintainable, would not be sustainable in law. Full stop. He has also informed that when the writ petition was moved on 4/2/2019, there was an interim order and the petitioners have not been disturbed from their peaceful possession. Para. The learned senior counsel has also drawn the attention of this court to the additional affidavit filed on 13/12/2014, in which a communication dated 2/4/1984 has been enclosed.
2024 it should be.
13/12/24.
20.
24 কোন হয় নাকি? 24. 13/12/262. In the said communication issued by the department to the Deputy Commissioner Kamrup, the provisions of the Act of 1959 has been explained, whereby it has been clearly mentioned that the rights which accrues on a tenant is to be given precedence, and such land cannot be treated to be at the status of any acquired land. Para. Three, Talukdar, the learned senior counsel, and additional senior government advocate Assam, has, however, submitted that the land in question is a huge plot and encompasses areas which is outside the area within the possession of the petitioners. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 6/12/2023 by the respondent number 4, the Learned State Council has submitted that there appears that there is an inadvertent error in the narration of facts in paragraph 13. Full stop. He has in fact placed before this court the original parawise comments dated 2011-2023 issued by the District Commissioner Karimganj, and has submitted that in paragraph 14 of the said affidavit, the word "not" has been left out. Full stop. For the sake of clarification, comma, the averments made in paragraph 14 of the affidavit dated 6/12/2023 and the parawise comments against paragraph 15 are extracted herein below separately. He has also submitted that there are many other dags apart from the dags on which the petitioner claims possession. Full stop. Para. Sri A. Bhattacharjee, Learned Council, Standing Council Revenue Department has submitted that from the materials on record, it appears that the proposed college would not touch upon the areas which are in the possession of the petitioner. Full stop. He has also submitted that it can be clarified by this court that by adhering to the principles of law laid down in section 15, the college may be allowed to be constructed as the same is in the interest of public. Full stop. Para. Ms. Mohanto, the Learned Standing Council Revenue Department, while Standing Council Higher Education Department, while endorsing the submissions of our colleagues, submission of the Learned Council for the respondents, has also placed before this court a communication dated 16/3/2026, as per which the construction work of the college is almost over, and there is physical progress of 99%. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully perused. Full stop. The petitioners have clearly mentioned the dags of the land under their possession, as mentioned above. Full stop. As mentioned above, such statements have been made in paragraphs 3 and 4, 4 and 5 and 6. So what was it?
6.
5 and 6, as well as the additional affidavit filed on 4/12/2023.
5, 6, and 7.
5, 6, and 7. 4 to 5, 6, and 7. There is, however, no categorical denial of the same statement. Full stop. On the other hand, a perusal of the impugned communication dated 26/10/2018 would show that the college which was proposed to be constructed is over the following dugs. Page 60. Though it appears that there has been bifurcation of certain dugs by inserting expressions KHA, comma, there are certain dugs like dugs 339 and which one? 339, 348 also.
341, 348, 355, 359.
No, 341 is co. 339 is there. 339.
340, 348.
348.
Yes, 355.
355.
And 359. No, 359 is co.
No,
359 is co.
355, which appears to be overlapping. Full stop. At this stage, comma, there is a clarification by the learned counsel for the respondents that since one dug comprises of a certain area, comma, a part of the dug can be a part of the college which was proposed to be constructed. Full stop. Para. The Act of 1959 has given certain rights of settlement with persons who are in occupation of such lands. Full stop. For already, I mean, 15 to quote already. Full stop. The said provisions which have already been extracted above makes it clear that if the status of occupancy tenant was acquired, the land in his holding would be settled with such persons. Full stop. The Honorable Division Bench in the case of Banikanta Sharma Supra has also clearly laid down that the preference has to be given for settlement to persons in occupation, and in this regard, the provisions on the definition of encumbrance as laid down in 2C as extracted above would make it clear that encumbrance would not include the right of a riot or agriculture or non-agricultural tenant. Full stop. Para. This court has also noticed that in this proceeding, an interim order was passed on 4/2/2019, staying the impugned order dated 26/10/2018. Full stop. However, from the recent communication dated 16/3/2026, it appears that 99% of the construction work is already over. Full stop. Though a strict view may be taken that such constructions would be in violation of the interim order of this court, this court is of the view that the present situation would require a harmonious construction in as much as the primary objective of the petitioners was to secure an interim order so that their rights are not affected. And this position has been made clear by the learned senior counsel, who has fairly submitted that the peaceful position of the petitioner over the lands have not been disturbed. Full stop. This court is of the opinion that while there appears to be some overlapping of the dark numbers as mentioned above, comma, the most of the dark numbers mentioned in the impugned order dated 26/10/2018 are not the DAGs of the lands which are under the possession of the petitioners. Full stop. This view gets fortified by the aspect that while 99% of the construction is over, comma, the lands of the petitioners have not been affected. Full stop. In that view of the matter, comma, the writ petition is disposed of by directing that while there would not be any restraint in the construction of the work which has been completed to 99%, comma, the rights of the petitioners as which have been granted under section 15 of the Act, under 15 and other provisions of the Act of 1959 should not be affected. Full stop. The writ petition accordingly stands disposed of. We'll hand this over the parawise comment later. We'll try to have the next. Forest, we can finish off your matter because this matter will take some time. We're going to dispose of the other matter. If you can have.
I'll call.
Forest.
Yes, D. Gogoi, I will ask.
Okay, please ask somebody to come. Just wait for a while. We'll try to complete that matter.
Yes.
May I please your lordship in this matter that they have filed one application of discharge before the recovery officer at DIT. And
Discharge means?
No, not discharge, my lord. Application for satisfaction of it.
Satisfaction of the?
Of the entire debt matter.
Okay.
So what has happened in the intervening period after this honorable court issues the order for provisionally winding the company up. My lords, in the intervening period till today, what has happened is there is a admission by them saying that 3.16 crores worth of security was available to them, which was eventually handed over to the OL in the Honorable Madhya Pradesh High Court, my lords. Because I'm the
security furnished on your behalf.
My lords, I'm the guarantor. I'm not the principal borrower before your lordships. Now,
we'll come to you. Just finish off this. Okay.
I just went through the prayer. Even
they want a de-reservation. Is it possible?
My lord,
not be possible.
My lord, there is a process had been initiated long back, my lord. Now, what is the present status also, my lord? Today morning, my lord, I tried to contact one of the person, my lord, who has 2016 matters, my lord. Whether these persons are still there or not, that is also not
doubtful.
Doubtful, my lord. So, my lord, a week's time may kindly be given.
No, we are not giving time. 16 matter.
No, my lord, only to ascertain, my lord, that what is the.
Whatever has been done has been done. 16 matter, not going to grant time.
I am not asking for a long day, my lord. Only.
Not even a day. 16 matters we need to dispose of. 10 years, writ petition. It looks very bad.
My lord, I can understand, my lord, and I also generally.
You'll be the first one to say that take up my matter first. Don't ask for an adjournment. No instruction, nothing. No, does not matter.
My lord, no affidavit, nothing has been given.
Whatever is there, we'll decide on the point. Whatever is available with us.
My lord.
I'll just point out, my lord, the averment at para 4.
First, let us see what is your case. Mr. Gogoi, have you sit?
My lord, the case is that, my lord, that we are.
How many of you are there?
My lord, we are at present, my lord, 52 numbers of petitioners, my lord. These were where we are residing, my lord, appears to be Forest Village, my lord, admittedly. Now, my lord, there is a move initiated by the government that these forest villages should be converted into, my lord, revenue villages by following the due process of law, if permissible under the law, my lord. For that, my lord, I beg to draw my lordship's attention, my lord, to page 29.
29.
My lord. Annexure 2 series, my lord. This is a letter of 1978. May I kindly appreciate the date, my lord.
before coming into the, my lord, this Forest Conservation Act of 1980, my lord. 12th of June 1978, from so and so Deputy Secretary Assam to the Divisional Forest Officer so and so allotment of land. I am directed to forward here with a petition dated so and so submitted to government by so and so ministers forest orders thereupon, and request you kindly to furnish a detailed report on the matter through the Conservator of Forest Hill, Assam, Gauhati 3 at so and so date. The position in original may kindly be returned along with your report. So, my lord, this is the process initiated, and thereafter, my lord, this again a letter.
Now, what is this process? What process? To
Process for, my lord,
furnish a detailed report on the matter.
report on the
What is
matter.
the matter? Allotment of land.
Allotment of land, my lord. That is the subject which they have decided, my lord. And secondly, same communication, my lord, is at page 32 from Deputy Secretary Forest Department to the Divisional Forest Officer of 1982, my lord. I am reacted to refer to the letter quoted above and to request you kindly to furnish a detailed report on the matter within a week. So, my lord, these are the communication continued till 1995, my lord, at page 35. Divisional Forest Officer, Silsar Forest Divisional, Silsar, allotment of land to so and so, Jamalpur Forest Village under Hawating Range, under the Divisional Forest Officer, Silsar. I am directed to enclose here with a copy of so and others of under Hawating under the so and detailed report in this Conservator of Forest so my lord.
You're reading at page 35.
Page 35 is the type copy, my lord. 37 is the original one, my lord. And secondly, my lord,
Deputy Secretary of the Government of Assam.
These are the, my lord, dag number and patta number had been mentioned, my lord, in page 40, my lord. Direction as instructed by you. The following dags may page number 40, my lord. I am reading 40, my lord. To the range officer Sunai Range, allotment of land of Jamalpur Forest Village under so and so. So, my lord, the issue is that, my lord, there was a process.
Who has written this?
My lord, this is being written by, my lord, the signature is there in the type copy.
Now, what is this?
This is a, my lord, mentioning the dag number and patta number addressed by some of the forest official to, my lord, to the range officer, my lord. For the purpose of allotment of land, if possible, under this, my lord, dag number, patta number and area has also been mentioned, my lord. Now, my lord, these petitioners has moved this honorable court long back, my lord, by way of a civil rule in 285-87, where an order had also been passed, my lord. May be pleased to peruse is at page 43, my lord. Annexure 4 starts and page 43, my lord. My lord can skip first few paragraph, my lord. May I read, my lord? A small order, my lord.
Yes, please.
The petitioner claimed to be resident of the Jamalpur Forest Village, PS Dolai, in the district of Kachar within the Hawating Forest Range under the Divisional Forest Officer Kachar. They claim to have been conducted there as laborers, whereafter they continued to stay in the said forest village, rendering occasional services to the forest department. It is their case that the back in 1974, there was an order from the office of the Chief Conservator of Forest Hills, Assam, to the Divisional Forest Officer Kachar, effect that nobody should be allowed to encroach the forest village land as they exploited the poor villagers of the locality for the purpose of cultivation, and as a result, the Mezu settlers who inducted the petitioner had to leave that place. But the petitioners continued. They made application for settlement of
yes,
land.
we have read this. Page 45 is the
operative part. Upon hearing the learned counsels and upon consideration of the facts,
you dispose of the representation within 15 days.
In case of original,
till such date, do not evict them.
My lord. Now, thereafter, my lord, our representations, my lord, has not yet been disposed and considered. And, my lord, and suddenly a move for our eviction, my lord, had been initiated. Then, my lord, we approached before this honorable court, my lord. Now, my lord, there is a process initiated by the central government, my lord, which we have relied upon. My lord may be pleased to find
page,
my lord, page 52. Page 52, my lord. Office of the Principal Chief Conservator of Forest, Rihabari, Gauhati 8, my lord. This is from so and so Principal Chief to the all Conservator of Forest, my lord. Regularization of pre-90 enforcement, my lord. as my lordship, my lord, has decided many matters, my lord, after the 1980 Act, my lord, it is very difficult that the forest land cannot be used for non-forest activities, my lord. So therefore, perhaps, my lord, this or letter had been issued that those who had, my lord, was settling, my lord, or were settling, my lord, in the forest areas, they can be settled, my lord, under this provision of law, my lord. So therefore, my lord, this letter has some bearing, my lord. In continuation of this office letter, and I am reading page 53, my lord.
Yes, please.
In continuation of this office letter under reference, copy and close, I am to again inform you that the government of India will consider regularization of pre-1980 enforcement, where the state government stands committed to regularize them on account of past commitments. Such proposal should invariably conform to the criteria given below. Pre-1980 enforcement, where the state government had taken a decision before enactment of the Forest Conservation Act 1980 to regularize the eligible category of enforcement. In order to fulfill such criteria, it will be essential at the very outset to provide adequate documentary evidences that such enforcement did take place prior to 1980 in a certain forest area. These documents may be prior to 1980. Records of enforcement with date, if any. So, my lord, basing on this, my lord, as the process.
But here there is a catch, there is a caveat.
My lord, my lord.
Pre-1980 enforcement, where the state government had taken a decision before the enactment of the Forest Conservation Act.
My lord.
That is, there has to be a decision to allot. What will happen to those? Those have to be regularized.
Exactly.
And before regularized, there are further conditions. Then you need to ascertain their claims, records of enforcement with date, details of records of enforcement, all those.
Oh, my lord, I have to submit fairly before my lord, that after the 1980 Act, my lord, as my lordship has also decided many cases, my lord, even the Abdul Khalek case also has been taken care of, my lord, wherein, my lord, it has said that after this 1980 Act, non-forest activity is very difficult, or those are not permissible. So now here is a case, my lord, there is a letter, my lord, which I have brought into my lordship's kind notice, my lord, that this process has been initiated from 1978, my lord.
Yes.
That there is
But was the decision taken?
But that is the issue, my lord. Those decision has not yet been brought on record by the authority, my lord, in any form, my lord, neither on by of an affidavit or whether it had been rejected. My lord.
There would be the burden will be upon you. You have brought to the notice of this court that there were some movement,
my lord,
that asking for a detailed report.
My lord.
But to put the burden upon them that they have to come that no decision was taken will not be fair, and that is not the procedure. You have to make out a case that before 1980 coming to Act, there was a decision taken, in spite of which you are sought to be evicted. Then you may get the benefit of this letter of 1/3/2003.
My lord. But my lord, it is very.
Till then, we'll ask them what has happened.
My lord.
That is your case.
That is our case, my lord, that if some decision is taken that we are 1980 pre-settlers, my lord, we are entitled to this benefit of this letter, then we have a case, my lord. Otherwise, it is very difficult. They will have to follow the guideline of the Abdul Khalek, and my lord, will produce whatever we have before the committee, and they can evict us, my lord.
No, that recourse we already have,
my lord,
Abdul Khalek, but we are just trying to.
My lord. Yes, my lord.
Hear what is there.
My lord.
What was the cause of action?
My lord, the cause of action was for the eviction process, my lord.
Where is the eviction process? Is there?
No, my lord, the notice had not been issued, but there was a, my lord.
Let us see your prayer.
Appended with the my lord, the prayer is. My lord, may be pleased to find starts at page 23, my lord. So do they for the conversion? No, my lord, it is not the eviction. Jamalpur Forest Village under so and so to Revenue Village, my lord. The guideline and the process which the government had initiated, my lord. That was our prayer at that relevant period of time, my lord, 2016, my lord. Under the policy which the central government has initiated, my lord. If we are entitled that policy, my lord, then only, otherwise we cannot claim these benefits, my lord. Lord, one thing I have not brought my lordship's kind notice, my lord. That is the another, my lord, letter. My lord. Actually, my lord, I forget about this case, my lord. It was in my chamber, my lord. Some very important documents are appended, my lord. Another, my lord, at page 67, annexure 8, my lord. This is of, my lord, 8/11/2013, my lord. Page 67.
But Mr. Bhuya,
My-
the aspect of Abdul Khalik will also not come in. Your per se not against any eviction process.
No, my lord. We are
Yours is for conversion of a forest
Forest village.
land into revenue
Revenue
village.
village.
In fact, those letters, communication would also not be directly connected with your prayer. You had only stated that you want to be allotted land. Now, your prayer
My-
is only for conversion. Let us see what is the procedure for conversion. What is 67?
Page number
67,
67,
you
my
wanted
lord,
to
is
show
a letter,
67?
my lord, issued by the, my lord, Government of India Ministry of Tribal Affairs, Chief Secretary, conversion of all forest villages, all habitation, unsurveyed villages, etc. into revenue village under section 3(1)H of the
That is
city-
under the 206 Act.
2006 Act.
You have to be scheduled tribes or other
Other
forest dwellers.
Other forest dwellers, my lord.
And that needs to be certified by the Gram Panchayat.
My lord, and 75 years residence is required to be proved 3 generations, my lord.
3 generations.
My lord.
That would be difficult for you.
My lord. No, just for
That is
the,
only for 2006 Act. We have dealt with that Act.
my lord, my lord.
Other forest dweller and ODC and another expression.
Scheduled caste and scheduled tribes people will get the benefit, my lord.
Traditional forest dweller, TFD and other traditional
My
forest
lord,
dwellers.
my lord.
Yes, Mr. Gogoi?
My lord had rightly pointed out, my lords, that they have admitted in their petition, they have come to reside in this very area in 1974. Para 4 of the petition, para page 15. So they don't fall under the, they don't fulfill the criteria of the 2006, my lord, definition, clause 2(O). 75 years of 3 generations, my lords. And their department, they are heavily relying on this communications, my lords, that some communications are made. And I have a Supreme Court judgments, my lords, because mere interdepartmental communications cannot rely as it cannot be a foundation of any right, my lords. And the department, I am having.
What is that?
This is Miss, my lord, this is Mahadev and others, my lord. This is 2022 Life Law SC 730. I'm handing over the copy. Bachatra Singh has been.
No, Bachittar is a different matter. Unless it is in the form of an order, office notes will not will vest any right. But Bachittar is different. But we have to address on the main issue. Because whatever Mr. Bhuya has said, we will not go by that. We will go what is there in the petition. Petition, there is a prayer that their claim for conversion needs to be considered. So we need to know from you what is the procedure for converting a forest village into a revenue village. Number one, whether that is permissible. And if it is permissible, what are the procedures and what are the safeguards to protect the environment? It cannot be done in a routine manner.
But on that aspect, my lord, the 1980 Act is very clear. Central government has to be brought into the picture for the reservation of any kind, my lord.
Yes.
So when the first prayer goes, my lord, second prayer, my lord, I think doesn't survive. Because the
First prayer means?
First prayer, my lord, had pointed 2 queries at me. That is it permissible first? And if is it permissible, what are the safeguards enumerated in the Act or provisions? So if the first prayer if it is answered in negative, that there is
Now, it is permissible. You can, but you have to fulfill a number of
criteria, my lord, which is Act has laid down.
Like, kindly show us the Act. This is what paragraph? Bachi, this one.
14 and 15.
Mahadev.
14 and 15 minutes.
Mercy to Forest Act.
No, it's
Now, first you placed that 1980 Act.
1980 Act was also there.
Different, yeah. You can make a submission from your court.
My lords. 1980, my lords, section 2. Any kind of reservation is prohibited, my lords, without enroping this.
Just a minute, Yes, now you want to place 80 Act?
Yes, 80 Act. Section 2, dear friend.
Just a minute, please. এখন নহয় এখন পড়েছে না আচ্ছা 290 yes is there. The Forest Conservation Act 1980. Yes,
Section 2, my lord, restriction on reservation.
yes.
Notwithstanding anything contained in any other law for the time being in the force, no state government or and other authorities shall make except with the prior approval of central government may order adequate so and so, but they follow the 2. 1, 2.
Yes. First is that has to be a prior approval of the central government. Here there is no such pleadings or anything prior approval. But Mr. Bhuya is emphasizing on the aspect that before coming into operation of this act, there was a move to allot lands.
Exactly.
So, but that move, and there is also communication. Communication, of course, cannot override the requirement of this act. Communication is for those where a decision has been taken to regularize those, because those decisions have been taken prior to coming of the act. Now, here, apart from forwarding or asking for a report, we don't find any decision as such.
No.
In that case, Mr. Bhuya has been finally said that this is what he is equipped with to place. Otherwise, if there is a decision, if you can show the decision, of course, you have not filed any affidavit, but that burden of would be on the petitioner.
And second matter, I'll go to the Act of 2006.
Yes.
You claim those rights also under 3, they're claiming perhaps right under section 3H. 1H.
One.
3(1) sub H. Rights of settlement and conversion of all forest villages.
3(1) sub H. 3(1)H, yes.
But to be entitled for this matter, they have to satisfy 2O, section 2 sub O.
Yes.
They don't fulfill this criteria also. Admittedly, my lord, they have yes, they have averred that they have come in 1974. In that part, my lord, very recently, the Supreme Court, my lord, in a case, the order dated December 18, 2025, my lord. Has again uphold that that section 2 of Conservation Act has to be strictly enforced. And Lordship, I have handed over order sheet, my lords. There is a paragraph 11 there in my lords.
Of?
That order, my lord, there is a paragraph 11.
Just a minute. Para 11.
Para 11.
Yes.
11, Lordship, reads my lord in bold black letters.
Yes.
Below, my lords, Lordship will find pending further orders, no reservation of forest, sanctuary, national parks shall be effected. And points to citation, bottom of the page, 2000 SCC online SC 119. This is still pending, my lord.
Godavaran.
This is not Godavaran.
Godavaran is there.
No, my lord, this is Center for Environmental Law, WWF versus Union of India. Godavaran is there, but this is also there.
Okay, yes, yes. The Center for Environment.
Yes,
That is the 2000.
Yes, madam. It's still pending.
Yes.
It says no further reservations.
Yes, yes.
This order is still subsisting, holding the field.
Mhm.
And then para 14, final ultimate paragraph, the Conservation Act has been reproduced. Actually.
14.
14. The apex court has laid emphasis on the section 2.
No, that part,
Yes,
Mr.
but
Bhuya
that's-
has fairly considered
Yes,
that
considered.
now the aspect of conversion has become extremely first prior approval, and Supreme Court itself, apart from the central government, Supreme Court has said that you cannot.
My lord.
It has to be an extremely exceptionally different, it's an exceptional case where there is a requirement to convert.
This ring road project, my lord, they have moved the central government, my lord, for de-reservation of Amsang
Permission
forest,
granted.
my lord.
Both
Recently,
final
my lord.
approval has come.
Even that might be a subject matter of challenge.
It is a challenge.
Yes, yes.
As a PIL.
There is
There's
a PIL pending.
Yeah, there may be subject matter of challenge.
That's all, man.
Okay. Oh,
And
please.
that para 11, I pointed out that still holds the field.
Okay, please write.
Pending natural amendment.
52 numbers of writ petitioners have joined together in filing this application under Article 226 of the Constitution of India with the following prayer, prayer to Kut Kodiba. Para. As per the facts projected, the petitioners are residing in the Jamalpur Forest Village under Hawaii Thang Forest Range in the district of Kachar. Presently, what Sribhumi?
My lord,
Kachar is
no,
Kachar.
it's Kachar, still Kachar.
Karimganj is Sribhumi.
Karimganj is
Okay.
Sribhumi.
Kachar. Since a long period of time, full stop. There has been approaches made by their predecessors for allotment of land in their names, full stop. The petitioners had earlier also approached this court, and there was a direction to consider their cases, full stop. However, as no action has been taken for allotment of land, including by converting the same into revenue villages, the petitioners have approached this court, full stop. Para. I have heard Sri A.R. Bhuya, learned counsel for the petitioners, full stop. I have also heard Sri D. Gogoi, learned standing counsel, Forest Department. Para. Sri Bhuya, the learned counsel, has submitted that though the Forest Conservation Act had come into force in the year 1980, there have been there have been moves to make allotment of land to the petitioners by converting the same into revenue villages. Full stop. In this regard, the learned counsel has drawn the attention of this court to various communications dated 12/6/1978, 20/2/1982, and 28/6/1995. Full stop. While by the in all those communications, detailed reports were called for to initiate the process. Full stop. The learned counsel for the petitioners has also referred to an order dated 6/3/1987 passed by this court in Civil Rule 258 of 1987, wherein there was an observation for disposal of the representation of the petitioners by the forest authorities within a period of 15 days. And within those 15 days, no move be taken for their eviction. Full stop. Reliance has also been placed upon a communication dated 1/3/2003 issued by the Principal Chief Conservator of Forest to the Conservator of Forest on the aspect of regularization of encroachments pre-1980. Full stop. He has submitted that the petitioners have been in possession of the respective lands prior to the aforesaid enactment of 1980, and therefore the allotted land. Full stop. The learned counsel has also relied upon the scheduled tribes and other traditional forest dwellers within bracket recognition of Forest Rights bracket close Act 2006, and has submitted that even under the said act, the petitioners would be entitled to certain benefits. Per contra, Sri Gogoi, the learned standing counsel, Forest Department, has submitted that the Act of 2006 would not come into operation in this case, in as much as the petitioners do not fulfill the requirement of the said act. Full stop. By drawing the attention of this court to the averments made in paragraph 4 of the writ petition, the learned standing counsel has submitted that the petitioners came to reside in the aforesaid area sometime in the year 1974. Full stop. He has submitted that admittedly the petitioners would not come within the definition of forest dwelling scheduled tribe as defined in section 2 within bracket C, and the only other definition which may come into operation is the definition of other traditional forest dweller as defined in section 2 within bracket O, full stop. However, the said definition also requires that a member of the community should be there for the last 3 generations, and this condition is also not fulfilled by the petitioners. Full stop. As regards the communications, various communications relied upon by the petitioners, the learned counsel for the department has submitted that inter-office communication would not vest any right. Full stop. In this connection, he has placed reliance upon the case of Mahadev and others versus Srimati Sovan Devi and others reported in wherein the following observations have been made. And the relevant observations made by the Honorable Supreme Court are extracted herein below. More relevant. With regard to the principal prayer for conversion of forest land into revenue land, the learned standing counsel has submitted that the Act of 1980 lays down a clear restriction in section 2 for such de-reservation. And one of the essential requirement is the prior approval of the central government. Full stop. He has submitted that no such prior approval of the central government could be brought on record by the petitioners. Full stop. In this regard, he has also placed reliance upon the case of the Honorable Supreme Court in state of Karnataka and others versus Gandhi Jeevan Collective Farming Cooperative Society Limited, reported in 2025 INSC 1461. Full stop. In the said case, the Honorable Supreme Court has referred to the case of Center for Environmental Law, WWF-1 versus Union of India, reported in 2000 SCC online SC 119, wherein the observation that no de-reservation would be affected is still operative. Full stop. The strict interpretation of section 2 of the Act of 1980 made in the said case in paragraph 14 has also been pressed into service, which reads as follows. Paragraph 14 to quote the rival submissions have been duly considered and the materials placed before this court have been carefully perused. Full stop. As indicated above, the prayer in this writ petition is for conversion of the Jamalpur Forest Village under Hawaithang Forest Village to Revenue Village. Full stop. Conversion of forest areas has to be dealt with in accordance with the Forest Conservation Act of 1980, wherein there is a clear restriction on de-reservation of forest or use of forest land for non-forest purpose. Full stop. For ready reference, the aforesaid provision is extracted herein below. Full stop. Section 2 to quote. Amongst others, there is a requirement of a prior approval of the central government for such de-reservation, which is not there in the instant case. Full stop. The learned counsel for the petitioners had relied upon a communication dated 1/3/2003 issued by the PCCF to various conservators of forest on the aspect of regularization of pre-1980 encroachments. Full stop. However, a bare perusal of the said communication would reveal that such regularization is possible only when the state government had taken a decision prior to the enactment of 1980. Full stop. In the instant case, admittedly, no such decision could be brought on record. Full stop. In any case, considering the objective of the Act of 1980, de-reservation of forest land cannot be done in a routine manner, and only in exceptional cases such de-reservation may be possible, which would need overwhelming public interest. As regards the communications of 1978, 1982, and 1995, this court is of the view that such communication by which a detailed report was called for would not vest any right on the petitioners, full stop. In this connection, this court finds force in the argument advanced by Sri Gogoi, the learned standing counsel, who has relied upon the case of Mahadev Supra, wherein the Honorable Supreme Court, by relying upon the earlier cases, including the case of Bachittar Singh versus State of Punjab, reported in AR 1963 SC 395, has laid down that interdepartmental communications would not vest any right. As regards the Act of 2006, this court is of the view that the said act would not come to the aid of the petitioners, as they would not fall within the definition of forest dwelling scheduled tribal as per 2C, or within inverted comma other traditional forest dweller as per 2O. Put stop. Sir, in view of the aforesaid discussions, this court is of the opinion that no relief can be granted to the petitioners in this case. Put stop. Accordingly, the writ petition stands dismissed.
Obliged, deeply obliged.
Good side you will. Yes.
My lords.
You have said that there has been some development
There
during
have
the.
been significant development.
Okay.
Now, to recapitulate, after the provisional binding of order is passed by this honorable court, there were a series of actions which were conducted before the court of the recovery officer. This entire case is predicated on a action before the honorable DRT Calcutta matter.
Okay.
I am a guarantor of the debt. I'm not the principal borrower.
Who's the principal borrower?
Michael Fibers Limited.
But you are at par, guarantor or a principal borrower. But as a matter of fact, you are saying that you are a guarantor.
No guarantor.
Okay. Now that that has been fulfilled.
No, my lords. So the principal winding up proceedings against Michael Fibers Limited were conducted.
What is the name? Michael
MAIKAL. Michael
MIK
MAI, your lordship.
MAI
KAAL.
Michael
Fibers Limited. My lords.
was the principal debtor.
Was a principal debtor, my lords.
Okay.
Now, in a action, an HDFC Bank, which is the petitioner before your lordships, was also a participant before the Honorable Madhya Pradesh High Court, my lords, where the principal winding up proceedings were.
It was in the MP High Court.
MP High Court, my lords.
Winding up proceedings.
Winding up proceedings.
Under the Companies Act.
Under the company.
Okay.
Thereafter, my lords, the company is ordered to be liquidated. OL
Orders passed for liquidation.
Orders passed, my lords. Now, the assets in the hands of the OL are still pending disposal, my lords. The assets of the principal borrower has not been so far fully auctioned, my lords. There are multiple reports of the office of the OL which has now been filed before the recovery officer in Calcutta, certifying that, my lords. Now,
how are you aggrieved now? What?
My lords, now my position today before your lordships is, if the debt has not been crystallized as qua me, my lords, there is a difficulty here. The assumption is, if now there is another leg of the argument, my lords, what happens is, before HDFC Bank goes to the MP High Court to participate in the winding up proceedings, my lords, a recovery certificate is already granted in their favor.
Okay.
The DRT Calcutta finds it in their favor, issues a recovery certificate of 2.55 crores, my lords.
This was in Calcutta High Court.
Calcutta,
DRT.
the DRT Calcutta.
Debts Recovery Tribunal,
now-
Calcutta Bench 2.
Issues recovery certificate in their favor.
In their favor of 2.55 crores.
But they had initiated recovery proceeding in the DRT
In the
Kolkata
DRT proceeding, even before the winding up.
against
gets initiated.
Michael.
Michael, yes, ma'am.
Your lordship, Michael Fiber and its guarantor.
It doesn't matter. Okay, okay.
A recovery certificate, thereafter recovery certificate of 2.55 crores is issued, my lords, in their favor. They, back in 2008.
Yes.
Now, they were sufficiently collateralized at that point, my lords. They had current, and according to their own affidavit, their own admission, my lords, they had current assets worth 3.16 crores and certain other FDs and all of that, which were basically available to them, my lords, highly liquid assets. And they had the first charge on plant and machinery, my lords, totaling up to almost 29 crores at that point in time.
Okay.
They did not take any action. This has now been recorded by way of judicial orders, my lords. They did not take any action, my lords, in the intervening period of the recovery certificate being issued, and then the winding up petition started before the Honorable Madhya Pradesh High Court, my lords. They then voluntarily step into the winding up, saying that here is my first charge and here is my charge on my current assets. Please appropriate. Now, my lords, what has happened is 3.16 crores worth of cotton has now been lost as security. Nobody knows what has happened. The list of current assets were drawn in their presence before the learned DRT Calcutta, my lords. It is their admission. Their officers drew it up. They then say that, okay, we handed over physical possession of the cotton to the office of the OL before the Honorable Madhya Pradesh High Court. The office of the OL is then requisitioned by the office of the recovery officer, my lords, Calcutta. And there is a report which is issued as early as 2024, later, sorry, 2024-25 also. And my lords, there is another order in 2026 where a revised oil report has been requisitioned, my lords, saying that specifically asking where is the cotton. Now, multiple reports have been filed. The OL is silent on the cotton, my lords. So, eventually an application.
What is your activity, Mr. Khanna?
My lords, I was a cotton mill, my lords.
You are a cotton mill.
Yes.
Okay.
Michael Fiber.
Michael Fiber is a cotton mill.
You're the guarantor.
I'm the guarantor. I'm a tea estate.
Oh, you are a tea estate.
In Dibrugarh.
Now,
Mrigan Jalan and Salini Jalan is
2021, my lords, as early as 2021, I bring this fact before this honorable court as well as the office of the RO, my lords. Notices has been issued by the office of the RO on my application for satisfaction of that. Now, that litigation is
now this CO is filed by you.
Yes.
Why? This company petition is for what purpose?
for winding up, your lords.
Winding
The
up.
Chota Tingrai being the guarantor to the main company, that is Michael Fiber.
there is an averment, my lords, in their company.
And regarding which debt?
Regarding the entire debts, your
The
lords.
entire debt where he was the guarantor.
Yes, your lords. Guarantor's liability is coextensive with.
No, that is okay. That there is no dispute with
Until
that.
date, we have only recovered 66 lakhs only. So remaining.
Now,
debts they have-
what about your winding up proceeding wherein Mr. Khanna has said that the assets are still pending for full auction?
No, your lordship, that report is not being filed, your lordship.
That is already
Now,
before your lordship.
your lordship, on 25/4/2024, some reports has been directed them to file before your lordship, but that report has not yet been filed. And no copy has been given to me.
No.
Your lordship, 25/4/2024.
Which in this proceeding?
Yes, your lordship.
In the main case?
Yes, your lordship. No, your lordship, in this IA. In this IA, your lordship.
IA 10.
Yes, your lordship.
My lords may have page number 276. That gives you the summary of the assets which are still pending before for disposal before the Honorable MP High Court.
But no report is being filed before your
No, the
lordship.
report of the OL has been made a part of the as an annexure, my lords, of the supplementary affidavit. My lords, we are on a short point today. We are only on the disposal of an application filed under 466 by me, my lords.
IA is filed by you.
Yes,
your
sir.
lords.
Praying for a relief under section 466 of the old
Hold
Companies
that.
Act, my lords.
Company
Lordship, for disposal of this application, because their main challenge is only to that regard, that is the cotton.
No,
Of what rupees 316 lakhs. And to that, they want to equalize the total debts.
I'm on a different footing, my lords, respectfully.
Just a minute. এখন না আগৰ এক এখন নতুন এক এখন 13 এক
Where is the report file of before the RO?
পুরনো কি Is there any equivalent section in the new act?
In the new act, the new act would go before the NCLT.
No, understood. But that equivalent provision.
No, my lords, I mean,
What is the
that would be an IRP procedure, my lords, I mean, that's. Here also, my lords, a point to be considered is that the OL has still not taken charge of the affairs of the company, my lords.
1956 or company clause exists.
My lords, that's what happens.
We'll have
Pull up 46. Give me the open order.
OL's view has been taken.
No, my lords. What has happened here is after the provisional binding of order was passed by this honorable court, a notice was issued by the office of the OL for the 454 and other formalities to be completed. Since then, we have appeared before the office of the OL, my lords. Now, when the statement of affairs of the company was requisitioned by the office of the OL, and I've stated so on my affidavit as well, my lords. Instead of the statutory period of preceding 7 years, the OL by hand strikes off 7 years and writes 14 on the form, to which I raise an objection and therefore come before your lordships seeking intervention.
Now, this proceeding was initiated by the bank in the year 2015.
Yes, my lords.
What was the orders passed? Was any order passed?
My lords, there was a
lordship order dated
in 20.
This is a winding up proceeding against you.
In 2019, there was a provisional binding of order. which was signed by me.
2019.
Thereafter, after I preferred this application, which is before your lordships for disposal today, my lords, an order was passed dated 4/10/2023. I'll read, my lords.
No, see, your application itself is pending since the last 3-4 years.
My lords,
We decide the entire case. Why do you?
I appreciate that. my lords.
What is the point in suppose we agree with you for the time being, we stay the proceedings
Right, my lords.
or further proceedings qua the provisional order of winding up.
Right, my lords.
But with this 15 case has to be decided.
My lords may consider just one point, my lords.
15 case,
If
in the 15 case, it is principally against the guarantor,
Yes,
principally, exactly, my lords.
not against the debtor.
And they have come prematurely before this honorable court, my lords.
that question has been
The-
decided.
No, so it may be there are subsequent developments which has happened, my lords. They have also come on affidavit to confirm my position. Now, the assumption is this, my lords. Let's assume that this honorable court finds it in their favor, and I am liquidated today. My lords, I am successful before the DRT Calcutta. My debt is satisfied.
Now, what is pending in the DRT Calcutta? Is there anything pending?
Is for hearing your lordship on the petition filed by Salini Jalan.
14th of May 2025, my lords, my IA 132 of 2021. And they have been delaying that also, my lords. After 4 years, they have filed a reply to my application. It is listed for final hearing, final disposal on 14/5/2025, my lords.
25 or 26?
2026, sorry, my lords. If I'm successful, and this is my principal submission, my lords, if I'm successful in recording satisfaction of the debt on whatever grounds, my lords, that is not before your lordship consideration, that is before the office of the RO and the DRT. My lords, the entire case becomes redundant. The predicate.
See, there are 3 proceedings which you have understood.
Yes, my lord.
MP winding up against the debtor.
Still pending.
Yes,
My lords, the disposal of the assets are still pending, which directly affects me.
The order has been passed, but
Orders have been passed.
entire matter has to be it has not culminated into an auction proceeding or whatever.
Yes,
It's still proceedings.
No, my lords. Part
Some
auction-
assets are there.
auction has
Some
been
assets
conducted,
are
there
there.
balance assets left.
Now, in DRT Kolkata, what is pending?
DRT Calcutta, my lords.
Recovery of qua whom?
The
Principal debtor.
satisfaction of the 2.55 crore recovery certificate which was issued against the group, my lords, that is pending adjudication and recording. of
Vote
certificate.
against you and the debtor.
No, my lords, the principal debtor, which is now wound up, and the co-guarantors.
You
I am one of the
co-guarantors and
co-guarantors.
Michael.
Your
There
lordship,
are-
Michael
there are-
Fiber has already been pulled up.
Michael Fibers is basically now in the hands of the OL, my lords. There are assets which are
Okay.
pending for
Okay,
disposal.
okay,
That's number
correct,
one.
correct,
my lords.
correct. Michael is gone, okay.
Now that is the stand that I'm taking. My debt has not been crystallized, my lords. I'm a guarantor of debt. First, the recovery has to be done by the
When is
principal.
it? 14th of May.
14th of May 2026. It is for disposal of
Okay.
the application for satisfaction of debt, my lords.
Okay.
Filed
And
by
my
the,
contention is this.
Okay,
that-
well, no, we'll not mix up proceedings. We'll have it after 14th of May.
My lords.
We'll have it after 14th of May. If you fail, then we'll adjudicate, but we'll not go for the I. We'll go for his application.
Entire-
My lords, there
No,
is
your
one more.
lordship,
See, in an application, as you know, Mustaq Khanna, there are hardly any scope of any
My lords,
resisting.
in any other condition, my lords, I would have conceded to your lordships, my lords.
And
There's
there
only
is
one
no
more
question
aspect.
of resisting. If he fulfills the primary condition that you are a debtor or and there is no
I'm
differentiation between.
I'm addressing your lordship directly on that point, my lords. There is a dual relief which I have prayed for in my 466, my lords. One is stay of winding up proceedings till such time the satisfaction is recorded or whatever the outcome may be, my lords. And number two, the mandate of a winding up court is to explore a way where I can be revived, my lords.
No, that is correct. That is correct.
I have moved
The,
in
the purpose is not to see that the company comes to an end.
Yes, my lords. I have moved in.
Okay. These are provisions given to secure a debtor, whether secure
my
or
lords.
anything, to recover. Okay, we'll do one thing. Third, Sri M. Sharma, Learned Counsel for the applicant, for the company petitioner.
company.
Also heard Sri. You were right. What Khanna?
K. Khanna.
K. Khanna. Learned Counsel for the respondent, who is also the applicant in IA 10
Yes,
of
sir. Yes,
2015. Full stop. The IA has been filed under section 466
466, my lords.
of the
Companies
Companies Act
1956.
1956 for stay of the present winding up proceedings. Full stop. Amongst others, Sri Khanna, the Learned Counsel, has informed that a recovery proceeding was initiated in the DRT Kolkata,
Yes, ma'am.
in which his client has filed application, which is slated to be stated on
14th of May 2026.
slated to come up for hearing on 14th of May 2026. Full stop. He has also submitted that his debts have not been crystallized,
Yes, ma'am.
and therefore final passing of any final orders in the present company petition would cause immense prejudice to him. Full stop. He has also informed that though a winding up proceeding was filed in the Madhya Pradesh High Court by the present bank,
No,
not by you.
we have not.
No,
Who had filed?
They have participated.
That is
Proceeding
the RCL.
in the Madhya Pradesh High Court, in which an order was passed, certain assets are yet to be disposed of, and therefore there is an amount of uncertainty on the amount that may be recovered in that proceeding.
My lords may observe that the proceeds post that disposal will accrue to them.
Okay, well, considering
Your
the
lordship,
above,
that may not be
No, no,
recommended
not
because
recommended.
already order has been passed.
considering the above, more particularly of the fact that the date in the DRT Kolkata is fixed on 14th of May 2026, the present matters are adjourned to be listed after adjourned for Tapkara in the interest of justice. to list these matters. When? Or we'll have it on 28th? Is it okay? 28, 28 May.
28th, we are not in the city, my lord. That's the only difficulty.
2nd of June.
2nd of June, my lord.
2nd of June.
Your Lordship, I think that IA number has been 1784 of 20.
Oh, 10, no, sorry, company petition 10,
Company petition 10.
IA 1784 of 2022.
Yes, sir.
15, company petition to 15.
Yes,
Okay.
yes.
You're correct.
Yes,
Okay.
highly obliged.
আমার এখন পুরোনো 1956 সালে ছড়ি দিবি এটা ম্যাটার এটা আইব নেক্সট টাইম একটু বলে ওকে our opinion.
Your Lordship, the observation in this order may not affect the proceeding before the RO, Your Lordship.
Obviously not, because nothing, it's only his submission.
His submission.
We have not expressed anything.
Yes, sir.
Or